Someone make it make sense.
Probably a couple.
Hello, hello, and greetings, squirrel friends of the world. How are y'all doing tonight? Happy to be here for the second live of today on this glorious, well, at least here, Wednesday evening. Let me know how y'all are doing. Christmas is quickly approaching. Holidays, all of the holidays. Shout out to Flash Fan. Shout out to Candace. Glad you guys are here. Yeah, whole lot going on in the world right now, in the world of law and other worlds, all of the worlds. That's okay. You don't have to apologize, but I hope you're feeling better. What are you sick with? Hopefully it's nothing too serious. I know there's a bunch of stuff going around right now, and especially with all at least here, the drastic changes in weather that we've been having recently. Sometimes that'll do it. So, but yeah, for anyone who didn't see it, I have a new thumbnail. Well, I guess I can show you guys, me as well, because nothing made me happier than finding the appeal, Alex Murdaugh's appeal, because I get to cover it again. Murdaugh, I mean. And so I made a new thumbnail for the appeal. And where is that? I'll share this to you guys real quick. Kind of changed up the font and the style a little bit. Let me share this to you guys. Here we go. So here's what I've got for the appeal portion. I don't know how many parts it'll be, probably a lot because it's like 150 pages or something. But we got all the classics. We got Poot, we got Bubba, we got the chickens. I didn't add the guineas just because I thought it might be a bit much, but we got Judge Newman. And this time we now have Alex, not in his courtroom attire, but in his new outfit that he has. Changed up the font a little bit. And so I have that scheduled here within the next couple days to go through the appeal. But yeah, so Flash had a stomach ache. I'm glad you're feeling better. Hopefully it won't deter you from eating any of your fried chicken. So let me share this back here. So yeah, so that's what I got going on with that. And he did not get a new trial yet. And actually what ended up happening is their whole bid for a new trial, as per the Miss Becky shenanigans, has been roped into this appeal. So it seems like the Supreme Court, the South Carolina Supreme Court, didn't see it as maybe as big of an issue as his attorneys hoped they had, because that was initially separated out and like separate from his direct appeal. That was like a separate issue, but apparently that issue is included in his appeal because it's all been combined into one, as in just include that in your appellate issues. So miserable. How is miserable? 85. Is that hot for you? That sounds amazing to me. That's like my kind of weather. As long as it's not raining. Oh, that's not good. That's not fun. Ew. I got food poisoning kind of recently from the baby carrots. Do you guys remember the baby carrot fiasco? This is from like, I don't know, a month ago or something, maybe a month and a half ago. If you guys buy baby carrots, you probably saw. Okay, interesting. I find that surprising because I know you're in California, and I thought not in the cooler parts, if I remember correctly. So that's crazy. Yeah, I mean, here it was hot today. Like it got down to like the, below 20 and whatnot for a little bit. And now it's back up into like the 50s and 60s. Actually, the real feel, quote unquote, temperature today was like 68, which is wild. We actually had some snow the other day, and now today we had rain. So Flash says it's cold in DC. So I got E. coli from the baby carrots, like I don't know, like a month and a half ago or whatever. I eat baby carrots like every day because you guys know I'm a squirrel and I love my raw vegetables. And it was awful. Oh, okay. Central Coast. Right. Okay. You got that wind coming off the waves. That's good. Awesome. I'm glad you ate a salad. Excellent. Don't worry, by the way, if you ate baby carrots, because they got that issue taken care of, to my knowledge. The baby carrots are safe and back on the shelves. So yeah. Okay. So tall order before us today. So the IGG and the DNA in this case. Okay. So this has been a whole thing, as you guys probably know. A lot of it is under seal, but there's things that aren't under seal. And so there was a lot of confusion from everybody, rightfully so. You guys will see why, on the last Kohberger live stream, because it was like, well, hang on, was the IGG used to from the knife sheath to connect it to the dad, or connecting the dad to Bryan, or what about the trash? And then what about, like, how did all this work? And it was like, I talked a lot about, like, did they go backwards or did they go forwards? Because the whole point is that it's supposed to provide an investigative lead, and that part of the issues that had been raised even early on from his defense attorneys, Bryan Kohberger's defense attorneys, was how did they get to him, right? Because it's one thing if you put a name, or you put DNA, okay, into an unknown source of DNA into a database, like, one of those familial databases, right? 23andMe, Ancestry, whatnot. And you use the DNA without any suspect attached to it, right? And you let that lead you to a suspect. Now, that generally takes a good deal of time. I mean, anywhere from weeks up until years, but it's not quick. And there's a whole process. And then that can lead you to a name. Now, it may not be the actual person. It could be a relative of the person. But the point being that you start with the DNA and you get to a name, right? And the thing here in this case is that the first thing they had was the car. And we're going to go through it. The first thing they had was the Elantra. And the first way that they got to his name was through the Elantra. So they had the name, I believe, even before they got the DNA results on the knife sheath. So anyway, you guys will see why there's a lot of questions about this. And this is really, really important, because this is a new frontier, as they say, right? Now, we all know that, well, maybe we don't all know. Let's just say it for anyone who doesn't know. IGG is not allowed to be used in trial, okay? However, it is allowed to be used as an investigative lead. And so the questions become, where did you rely on it? Like, in terms of, did you use it for obtaining a search warrant? Did you use it for obtaining an arrest warrant, right? And the reason this came back up in our discussions is because in all of the motions to suppress that we covered, and in the subsequent objections to the motions to suppress from the state, which we haven't finished going through, we went through many of them, the IGG keeps coming up a lot, because the main thing, well, one of the main issues for the defense is that everything is a result of a fruit of the poisonous tree, because they relied upon the IGG. Now, the challenge again becomes that a lot of the IGG, a lot of what they're backing that up with is under seal, as it has been from the beginning. But also, I just want to remind everybody that that's where the motion for a Frank's hearing is really important. And again, the memorandum in support of that is under seal, but it looks like that's going to happen. The judge so far has been signaling that that's going to happen. And remember, that whole thing is challenging the probable cause for a search warrant. And the standards, we've covered it, but just to reiterate real quick, briefly, that the standards for the Frank's hearing is if a law enforcement officer, in the affidavit, they have to have this affidavit, a sworn affidavit, attached to the probable cause for the search warrant, okay? And if there were statements made in that were knowingly or intentionally false or made with a reckless disregard for the truth, then anything obtained from that search warrant is now invalid, okay? And anything that results of that is fruit of the poisonous tree. Now, it could just be one piece of evidence. It depends on what resulted from that search warrant. So when you've got search warrants like we have in this case, where each search warrant yielded a bunch of different things, right? They were quite broad, overbroad if you ask the defense. Then, and also the same affidavits were used for each of the different states. So essentially, if there were problems in really any of the probable causes for the search warrants, you've got a big problem. Basically, will you even have anything left? Okay. So that's one thing, but we'll go through it. So Frank makes another appearance. Exactly. Yes. And okay. So here's the thing. The vast majority of the filings where we learn a lot of information about this case as it pertains to when did the IGG get involved? How did it get involved? All those things. This happened from summer of last year. Okay. Now, why am I saying that? A couple of reasons. First of all, I was not covering this case at that time. I started covering this case, I believe it was in spring of this year, after there were those spicy hearings regarding the jury questioning and jury surveys and whatnot, as they were going through the whole process for a change of venue. Now, of course, I was following it, but I wasn't covering it. But I wanted to add this into the mix. So in this same time period, okay? So in other words, even for people who were covering it, and even if I had been covering it, what you had going on at the same time, okay? Summer of last year. This is when you also had all of the media people. Look at all this. Look at this. All of the media people. Remember when they came in and they were all like, let cameras in the courtroom, and there was like a whole separate process of all these hearings. They were all about the media saying we want cameras in the courtroom. So you had all this going on with these people. These are all news people. Okay. Cameras in the courtroom. That was all going on. Look, press coverage. Okay. Photographic coverage, non-dissemination order. You also had, motions to stay the proceedings. You had your general, typical, requests for discovery and whatnot, right? Motions to compel. And some of this has to do with the IGG, and we'll get to that. But then you had, again, Shannon Gray coming in, representing the victims' families. You had, again, more stuff with the press. Again, press coverage. Then you also had, I'm sure we'll see it here very shortly. Oh, there's speedy trial. Then you also had all the bit with the alibi. Here we go. Alibi demand. So you had, in this case alone, in other words, the filings are coming out fast and furious, and they're dealing with at least three main different topics, right? The alibi, the press coverage, cameras in the courtroom, because that was a whole thing, and the IGG. And that's even if you don't consider things like the speedy trial and other issues, okay? So there was a lot going on, and I don't know that anybody covered all of the filings, even as it pertains to only one of the issues. I don't know that it was possible. And again, I was not covering it at the time. So I, in an effort to go back and try to clarify and go through all this stuff with the IGG and the DNA, because we all had different memories, but we had similar memories, but the memories, it's like things changed, right? It was sort of like unclear. And there's a reason for that. We will see. And so I went back through the entire docket from the beginning, and sometimes there's things related to IGG or DNA, but it doesn't say that in the title. So I had to go through and click on pretty much everything, you guys, to find the important documents that deal with the IGG and the DNA. And I've got a bunch of them pulled up. I don't even know that we'll get to them all. But for example, something like defendant third motion to compel, declaration of Ann Taylor and supported defendant's third motion to compel. These are two documents that have a lot to do with the IGG and the DNA. You wouldn't know it. So if you do a control F for IGG or DNA, it's not going to get you there. You have to click on them and open them up. So I've got a bunch of those links. But the first thing I want to do is this. Let me pull up, I'll have to unshare, reshare, but let me pull up, it's in documents, hold on. So the search warrants, because really, what are we dealing with here, right? Again, we're not worried about the IGG being used in trial, fine. But the problem is as it pertains to these search warrants, because if there were problems with the search warrants and what they relied upon for the search warrants, then, and if those problems are big enough, then it may not matter whether or not it's going to be used in the trial, because trial may be impacted, in other words, okay? So I'm going to pull up, okay. So we did last time, I think it was last time, we did go over portions, or I think quite a bit of the Washington State search warrant. Is that the one yeah, that's the one we did. Okay. So I'm going to share this to you guys in a second. Okay. I've got the Pennsylvania one. Okay. So let me share this to you guys. Where? Oh, I need to share it this way. Okay, here we go. So, you know, there's some states that don't even let cameras, like New York State and apparently Minnesota very rarely. I don't know. I couldn't tell you. I am full. You guys know I'm all about transparency. I don't know. I just don't know. I don't know if they're just not used to dealing with it or what the deal is. I think the cameras are a no-brainer. But in some states or jurisdictions, rather, they haven't allowed it. So then it's like a bigger deal. Now in Idaho, we've seen plenty of cases out of Idaho that have cameras, right? But I think that in terms of the cameras, a lot of people, at least in this case with Bryan Kohberger, were really concerned about the cameras like zooming in on his face, for example. Let me know, guys, if you remember what other issues they had specifically. But, I guess the media attention, I guess some people thought that by having cameras in the courtroom for the hearings, it would be harder to seat a jury. I don't know. I mean, none of the arguments really make sense to me. The only thing that I completely understand is not zooming in on the defendant, but it's easy enough to just say you can't zoom in on the defendant. We see this all the time, whether it's limiting the number of cameras or limiting the angle, or it's just saying, you can't zoom in. If you zoom in, you lose access. People do this all the time in these trials. So all of the Kohberger here, well, okay. Every Kohberger hearing that has been public has had cameras. They've had plenty of like in-camera hearings, sealed hearings. Of course, there's not going to be cameras for anything, but so far, we've not missed any of the public hearings, right? They've had cameras, and the trial we expect, well, trying to think if Judge Hippler has ruled on that or not. I would expect we'll have cameras. So, right. Thank you for reminding me about the fly. Thank you for being here also, but reminding me about the fly. So for anyone who's not familiar, that feels like a lifetime ago. At the very beginning of this whole thing, that might've been from like the arraignment, man. I feel like it was a rumor, right? Like that the camera zoomed in on his fly. I don't even know if that was something that was just like a TikTok thing where someone edited it. I didn't see that. I agree that it was silly. If that happened at all, yeah, that's inappropriate and stupid. So right. And the Zoom cameras, right now, but when there's not people appearing by Zoom, then they don't do it that way. Right. And then it's a bit different. It just depends, when they have when there isn't anyone appearing over Zoom, I don't think there's really been that many issues once they got it sorted out. What happened was Judge set a bunch of ground rules for the cameras, and people have been following it. So this is the search warrant from Pennsylvania. Now, again, why are we covering this? Because the whole question about the IGG and the DNA it's been continuously coming up. as it pertains to the most recent filings, which were the motions to suppress and the objections to the motions to suppress, they all, for the most part, have to do with IGG and fruit of the poisonous tree. For the most part, there's other things like the searches, the warrants were overbroad for other Fourth Amendment violations, but really, I think most of the Fourth Amendment, or alleged Fourth Amendment violations also pertain to the IGG DNA. And of course, we've talked a lot about the trash, and this relates to that because I really want to know more about the trash situation. And so it all comes back to, when is evidence suppressed, right? And this overlaps with the Franks hearing, right? Because in other words, there's items that could be specific pieces of evidence that could be suppressed for a variety of reasons. Under a Franks, if you have a Franks hearing, that's a bit stronger in terms that you're dealing with an entire warrant, search warrant, so that everything from that warrant would be suppressed versus just like a single item or a single piece of evidence. So another example for anyone who's been following the Shannon Gardner case, some of those text messages and whatnot that were in that category of like attorney-client privilege that may have been or could have been viewed by the state, one of the remedies there is those are going to be suppressed. And that was done without having to make a motion because it was through the rest of that process because of the pretrial litigation there. But again, suppressed, so they can't use it. So, but an entire search warrant, right? And again, a lot of the bases that was used for one warrant was used for all of them. Because a lot of it was copied and pasted. That is without question. So we will see. Okay, but this is for Pennsylvania. So what we're going to see is what are they using as their basis? That's what we're going to hope to see. So for the search warrant. So here's the receipt for property. So in other words, this is the things that they took. So just as an example, okay, if there's a problem found with this search warrant, okay, in other words, under the Frank standard, if the affidavit, which we're going to see, if there were statements made in this affidavit that were knowingly or intentionally false or made with a reckless disregard for the truth, if that is found, and if they do have the Franks hearing, and that is what is found, then all of this stuff, all of these items of evidence will be suppressed. They can't come in. And anything that is a result of these items can't come in. Fruit of the poisonous tree. Okay, so these are more items, lots of items, tons of items. My God. It includes swabs, by the way, people. Another leather sheath, another knife with a sheath. So I'm just scrolling till we get to the part where they're applying for the search warrant. Affidavit of probable cause. Here we go. All right. There were cameras for Chad, but not for Lori. But it was done in a weird way for Chad. Okay, so your affiant is Trooper Bryan Knoll. Now, why does that matter? Again, because the affiant, that's the person who's going to be held to that standard, right? Are any of his statements knowingly or intentionally false or made with a reckless disregard for the truth? On Wednesday, December 28th, 2022, the Pennsylvania State Police was requested to assist the Moscow Police Department. As part of this investigation, we reviewed reports and affidavits prepared by the Moscow Police Department, establishing probable cause for issuance of search warrants related to this investigation, which are included in this affidavit. Furthermore, investigators began physical surveillance of the property and area of 119 Lansdowne Drive, Chestnut Hill Township, and in the early morning hours, so that's in Pennsylvania, they observed Kohberger walking near this residence. Additionally, Kohberger's vehicle was observed entering the Indian Mountain Lakes development on December 16, 2022, and the vehicle is still believed to be on premises. Investigators are also monitoring Kohberger's cellular phone, which appears to be in the same vicinity of this residence. On Wednesday, December 28th, while conducting surveillance, investigators observed Kohberger traveling throughout Monroe County and arriving back at his residence on Lambston Drive. Now, remember, December 28th is the day they got the trash, the dad trash, as I've been calling it. Your affiants are requesting a search warrant be issued for the search and seizure of all items listed in the items to be searched, along with forensic processing. Your affiants are requesting all digital devices, including any vehicle, infotainment, computer systems seized, be forensically examined in a controlled environment, blah, 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 blah. Okay. Exhibit A, statement of Brett Payne. So this is, we've seen this again. This is what I was saying, right? This is Brett Payne of Moscow PD. I believe there's an additional affidavit in this as well. But again, like I keep saying, right? This is where if one of them is in jeopardy in terms of these search warrants, then they all three, I would imagine, are in all three as in each 3 states. But there's going to be some important pieces of information as it pertains to this with the IGG. So this is all background. But we want to remember, our goal here is to figure out how did they get his name, right? That's really what it comes down to, because the state, I feel like, has been putting forth the suggestion that the way they got his name was through the IGG, but that they didn't rely on the IGG for the search warrants. So let's just see. Okay, we're going past this. Okay. Again, this is background. The shoe print. Okay. As part of this investigation, or the investigation, an extensive search, commonly referred to in law enforcement as a video canvass, was conducted in the area of the King Road residence. This video canvass was to obtain any footage from the early morning hours of November 13th, 2022 in the area of the King Road residence and surrounding neighborhoods in an effort to locate the suspect or suspect vehicles traveling to or from the King Road residence. This video canvas resulted in the collection of numerous surveillance videos in the area from both residential and business addresses. I reviewed numerous videos, okay, talked to people. Okay, a review of camera footage indicated that a white sedan, hereafter suspect vehicle 1, was observed traveling westbound in the neighborhood, blah, 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 blah. On this video, it appeared suspect vehicle 1 was not displaying a front license plate. And I remember, I mean, whenever things came out in the media, whenever they finally shared things with the media, I remember this being the first thing, right? They had a vehicle and there was like, the vehicle doesn't have a front license plate, right? A review of footage from multiple vehicles obtained from the King Road neighborhood showed multiple sightings of suspect's vehicle 1, starting at 329 and ending at 420. These sightings show suspect vehicle 1 makes an initial 3 passes by the 1122 King Road residence and then leave via Elantra Drive. Based off of my experience as a patrol officer, this is a residential neighborhood with a very limited number of vehicles that travel in that area. So what they're saying is it's probably the same person. Why are they saying this? They don't have a license plate number. Okay. Upon review of the video, there are only a few cars that enter and exit the area during this time frame. So it has to be the same vehicle. That's what he's saying. Suspect vehicle 1 can be seen entering the area a 4th time at approximately 4:04. It can be seen driving eastbound on King Road. When suspect vehicle 1 is in front of the King Road residence, it appeared to unsuccessfully attempt to park or turn around in the road. It then continued to the intersection of Queen Road and King Road. You can see it completing a 3-point turn. Suspect vehicle 1 is next seen departing the area of the King Road residence at approximately 4:20 at a high rate of speed. It's observed traveling southbound on Elantra Drive. Based on my knowledge of the area and review of the camera footage in the neighborhood, that does not show suspect 1 during that time frame. I believe that suspect vehicle 1 is likely at the neighborhood at Palouse River Drive and Costanoga Drive. Palouse River Drive is at the southern edge of Moscow and proceeds into Whitman County, Washington. Eventually, the road leads to Pullman, Washington. Pullman, Washington is approximately, blah, blah, small college towns. Okay, here we go. Law enforcement officers provided video footage of suspect vehicle 1 to forensic officers with the FBI that regularly utilize surveillance footage to identify the year, make, and model of an unknown vehicle. The forensic examiner, blah, blah, has experience. His specific training, okay, blah, blah. After reviewing the numerous observances of suspect vehicle 1, the forensic examiner initially believed that suspect vehicle 1 was a 2011 to 2013 Hyundai Elantra. Upon further review, they indicated it could be 2011 to 2016 Hyundai Elantra. As a result, now we're getting to, remember the question, how did they get to his name? Okay. As a result, investigators have been reviewing information on persons in possession of a vehicle that is a 2011 to 2016 white Hyundai Elantra. This right here, people. Investigators were given access to video footage on the Washington State University campus located in Pullman, Washington. A review of that video indicated that at approximately 2:44 on November 13, 2022, a white sedan, which was consistent with the description of the white Elantra known as suspect vehicle 1, was observed on the WSU surveillance cameras. At approximately 2:53 a.m., a white sedan, which is consistent with the description of the white Elantra known as suspect vehicle 1, was observed traveling southeast, blah, 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 blah. The forensic examiner identified the vehicle observed in Pullman, Washington as being a 2014 to 2016 Hyundai Elantra. So now they've narrowed down the year from 2011 to 2016. They've narrowed it down 2014 to 2016. I don't know about the informants. The first... No, the IGG is all up in the Frank's hearing motion. We can go over it again, too, when we go through some of these. Well, we don't know what's in the Frank's motion because that's under seal. There's an entire memorandum with over 2,000 exhibits. Or sorry, it's over 2,000 pages. Sorry, it's over 2,000 pages. Remember the whole thing about it was being too long. He needed, Judge Hippler asked for them to point to specific things. It was over 2,000 pages long, and it's under seal. Okay, so at approximately 5:25 a.m., a white sedan, which was consistent with the description of suspect P01, was observed. Okay, it's doing more things. Look at this great map. Excellent. Yeah, I can totally tell what's happening there. Another excellent map. Well done, people. All right. On November 25th, 2022, Moscow Police Department asked area law enforcement agencies to be on the lookout for white Hyundai Elantras in the area. On November 29th, 2022, at approximately 12:28 a.m., Washington State University police officer Daniel Tango queried white Elantras registered at WSU. As a result of that query, he located a 2015 white Elantra with a Pennsylvania license plate, and there it is. The vehicle was registered to Bryan Kohberger, hereafter Kohberger, and there's where he was residing. That's how they got the name right there. According to the affidavit, that's how they got the name, because they were looking for the white Elantra, and somebody at Washington State University searched for the white Elantras that were registered at the school that matched the year, and that's how they got the name. That same day, another officer was looking for white Elantras and noticed one in the parking lot. It was an apartment complex that houses WSU students. They ran it through the license, and this had his license. And the license indicated, now, normally, if you're just living somewhere, right, that wouldn't be the case. But because this was student housing, right, that's why. So it was all affiliated with the school. So that it had his license with all of his info, right? And then they saw, look at this. The fact that they include this is crazy. Additionally, the photograph of Kohberger shows that he has bushy eyebrows. I mean, that's so subjective. Okay. Then they had the further investigation because of the body cam. He was detained as part of a traffic stop. They saw that he had the same car. He provided his phone number. You know, at that traffic stop, we've all seen that footage. You know, again, detained for a traffic stop. They realized that prior to this time, the Elantra was registered in Pennsylvania, which does not require a front license plate. They believe he's still driving the 2015 white Elantra. It was then queried in Hancock County, Indiana. Remember, they were pulled over on that cross-country drive. As part of this investigation, law enforcement obtained search warrants to determine cellular devices that utilize cellular towers in close proximity to the King Road residence. After determining that Kohberger was associated to both the 2015 white Elantra and the 8458 phone, investigators reviewed those search warrants. A query of the phone in these returns did not show the phone utilizing cellular tower resources in close proximity to the King Road residence between 3 a.m. and 5 a.m. And then we get more into the phone records. Let me see if there's the next affidavit here. Another great map. LOL. I believe there is one. Oh, there's not. Okay. So, but basically the reason I pulled this up is to show you guys that, and was there anything different in this one? Let me just see. To show you guys that the way they first got the name. How did they get the name? According to these court filings, these affidavits, it was through the car. Now, again, if any of this is again, knowingly or intentionally false or made with a reckless disregard for the truth, we have problems. So then we have Sergeant Blakers. Now, we did go over this a little bit last time. Let me just see if there's anything else. So here's Dustin Blaker. Yeah, this looks like almost identical, though, to the Brett Payne statement, which is interesting. Yeah, I think that it is. Yeah, again, the suspect vehicle one. So same thing here. Now, remember, like I said, this is a different state, people. This is Washington State. The first one, this one was Pennsylvania. The sworn affidavits are two different people, but the statements seem to be identical. So again, if you have a problem with one, you have a problem with them all. And they relied on the same shitty maps. Yay. Okay, so now let me go back to, okay, unshare, reshare. Okay. So, let me take a look at the chat here because I get caught up in reading these documents. Right. Well, yeah. I mean, yeah, the internship. I think that was mentioned in the affidavit. I just closed out of it, but as a suspect, right? I mean, because just applying for something doesn't, how they got to him as a suspect, right? University attendance. Brett Payne, I covered the hearing. There was that hearing, the first and only hearing where Brett Payne testified. That was from a couple months ago. I did cover that hearing. And I don't remember the answer to that question. When is the next hearing? I don't know. On the docket, the next one was scheduled, was going to be in camera. Right. That's what I'm saying. Yeah, I meant in terms of connecting him to the crimes. Yeah. Parking guys. Okay, so now, again, now I'm going in chronological order, okay, in terms of the documents, the big documents related to the IGG that are not under seal. So this is June 16th, 2023. Okay, so this is the motion for a protective order from the state, okay? So it comes now the state, okay, for protective order for information related to IGG. The FBI submitted the DNA to one or more publicly available genetic genealogy services to determine potential relatives of the suspect. Okay, so when I read this, what do you guys, when you see this, what do you think? So in other words, here's the thing. Typically, the way that IGG is used in these cases is when they don't have a name, okay? And I'm going to show you guys something here in a second. Well, I don't know when I'll show it to you. I've got something pulled up about how this is supposed to happen. But it's when they don't have a name, right? You start with a DNA sample, an unknown DNA sample, and you have no person, okay? Now, we know already from what we've gone over in this case, they already had a name, according to them from the white Elantra, but they had a name before they had anything else. They had a name before they would have even had the results on the knife sheath, all that, right? They had a name before anything else. And again, the way that this usually works is you don't have a name, and that's how you use it. You use it to get to a name, right? Or get to a family member's name. So here it says the FBI submitted the DNA to one or more publicly available genetic genealogy services to determine potential relatives of the suspect. So the wording here, I'm just taking this piece by piece. The wording here makes it sound like this could imply they already had the suspect in mind via the car, and they wanted to determine the relatives of that suspect. But that doesn't make any sense. That would only make sense if you think one of the relatives committed a crime, right? I mean, I don't know. The FBI then used common genealogical techniques to develop a family tree leading to defendant. So you see how that doesn't make sense, because this is, again, the backwards and forwards. Something's not, because, okay, again, if this said law enforcement found the DNA of a potential suspect at the crime scene I mean, I guess you would have to go give them the benefit of the doubt that they don't have a suspect in mind. The problem, again, is we know they had a suspect in mind first before they had any DNA. That's the problem. We know that they had the name first. That was one of the first things that happened. Okay, I'm just going to keep reading. The FBI then used common genealogical techniques to develop a family tree leading to the defendant. So again, this would make it seem, right, guys, like the family tree from the IGG led them to the defendant. Now, here's the thing. The way this works in normal cases, this would take a really long period of time. Like when you don't have a name, you have the DNA, some unknown DNA, it doesn't match to anything in CODIS, and then you do this whole process. And it can take at a minimum weeks, right? But well, it can take way longer. And that's how you might get to the defendant. And it would be a whole process. The thing, again, that's weird here is like long before any of that, they had a name. Do you see why this is weird? It's like, why was this? The question would be, why is this necessary, right? If you're not going to use it, because you can't use it at trial, and if you're not using this to rely upon for a search warrant or an arrest warrant or anything, why would you even bother with it, right? Do you guys see the question that I have and why that is my question? No, I don't think there's any trolls. Flash. Yeah, I don't know about informants. I mean, you know, do you guys see the question that I asked though about why would they have used, like, why was the IGG necessary, right? Like the IGG would only, it seems to me, right? Like the IGG would be necessary in this case if they felt like the white Elantra and the bushy eyebrows was not enough for probable cause for a search warrant and they needed something else. And I already closed out of the search warrants, but there's a whole part in there where they talk about DNA. And I covered it. I think I covered that on the last one. So hopefully you guys saw that because they do talk about it. They don't use IGG, but they talk about the DNA in the search warrants. So like if they thought they had enough, they wouldn't be mentioning it, right? If it was just a tip, but they already had enough. But if they didn't have enough and they're using it, like then they're trying to say they didn't use it, right? Because they, you know, I don't know. Am I making any sense? Because it seems like they did use it, but then they don't want you to think they used it. It's just weird. It's just weird. And I'm not the only person who thinks this, by the way, because I went back and watched from the time some of the other people on LawTube, because again, I was not covering this at the time. I was covering other things. And they all have been saying the same thing as me, which is this is really weird. This isn't how it usually works. It's kind of unclear. It seems like they did use it for a search warrant, but like they didn't. Anyway, okay, I'm going to keep reading. All right. The state seeks to protect from disclosure the names and personal information of hundreds of innocent relatives. Okay, we don't need the factual background. Okay, well, wait, hold on. Knife sheath. Okay, we do need this part. Okay. Law enforcement seized the K-bar knife sheath pursuant to search warrant. Search warrant. The Idaho State Police Lab located DNA on the K-bar sheath. The ISP laboratory determined the DNA came from a single source and the source was male. Once law enforcement had single source DNA from the K-bar knife sheath, they conducted what is called a short tandem repeat, so an STR analysis. Law enforcement submitted the STR DNA profile into CODIS. No match was found. Unable to find a match using STR DNA analysis, law enforcement decided to use IGG to find a lead. Now, again, is this necessary, though, if you already have a lead based on the car? Genetic genealogy allows individuals to trace, okay, blah, blah. Typically, okay, a SNAP profile is different than an STR DNA profile, star DNA profile. It's used more often for genealogical purposes, and here's a footnote. While star DNA involves looking at 20 regions within human DNA, a SNAP profile contains about 650,000 of the human genomes. I don't feel like that's a comparison that makes any type of sense because we got regions versus not regions. Anyway, okay. All right. The Genetic Genealogy Service then uses an algorithm to compare the user's SNAP profile to SNAP profile submitted to the Genetic Genealogy Service. blah, blah, blah. And then it shares their information. The user does not receive any genetic information pertaining to the other database users. So DNA profiles are not shared with each other. This same process used frequently by members of the public can also be used by law enforcement, referred to as IGG. Once a publicly available genetic genealogy service shows law enforcement potential relatives of the suspect. Now, what's funny about this is it could actually be the suspect themselves, right? Like they keep saying potential relatives, but like it could be the suspect. Like they could have, there's no way ahead of time to know it's only going to show me the relatives, right? Like that's not the way that works. It's going to show you whatever matches, and that could be a relative or it could be the suspect. Law enforcement applies traditional investigative and genealogical methods to build a family tree in an effort to follow the tree to the suspect or a close relative of the suspect. Family trees can be used to narrow down a potential suspect based on factors such as age, gender, opportunity, interesting, physical appearances. Okay, in this case, investigators used IGG to begin the process of developing a lead to the individual who left DNA on the Kohberger knife sheath. The Idaho State Police utilized a private laboratory to develop a snap profile from the DNA on the Kohberger knife sheath. The private laboratory started using genetic genealogy to develop a family tree, but after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent the snap profile to the FBI. This is where things are going to get interesting, and here's a footnote. For ease of reference, this motion focuses on the FBI's IGG efforts. Okay. That's not the interesting part. Don't worry, guys. Okay. But it is going to start to get really interesting here. Okay. The FBI uploaded the snap profile. They could then view the genetic genealogy services portal information regarding relatives of the suspect. Again, why is that necessary? Like according to what they say, they shouldn't need this, right? If they don't need this, if they already have it, okay. Again, if you're relying on it for a tip, as in to get a name, but you already have a name, and you're also not going to rely on this for a search warrant, then why are you bothering to do any of this? It doesn't make any sense. Based on information the FBI could see in the genetic genealogy services portal, the FBI went to work building family trees of genetic. Now, I reviewed the testimony from the hearing where they actually had that public, where they talk about how IGG works, right? And what's really interesting is this flies in the face of what the people said. What the people said is like, once they get that, once they're enlisted, it's their case. And once they get the name, they get the family tree and they have a close relative or a name, then they turn that case back over. But in other words, this part, I don't even think is true. Like the building like the FBI does not build the family trees. They enlist people. And if you guys want, we can review that testimony. I have it ready to go. I already have reviewed it as I was researching and preparing for this. And, but we can totally watch it, but this is literally not, the FBI does not build family trees. Okay. The genetic relatives to the suspect DNA left at the crime scene in an attempt to identify the contributor of the unknown DNA. The FBI built the family tree using the same tools and methods used by members of the public. Again, I don't think any of this is really what happens. For example, the FBI consulted social media viewed. It's not. Okay. They also consulted subscription-based databases. Okay, the product of the genealogy conducted by the FBI was a family tree that contained the name, birth date, and death date of hundreds of relatives, as well as familial connections between each other and the suspect, Bryan C. Kohberger. See, again, how would they know this if they didn't start with a name? Like, again, this to me looks like going backwards, where they had the name first from the car, right? And then, again, I still don't see the reason. This is why there wouldn't be any reason to do this, right? This is why none of this makes sense. There wouldn't be any reason to be doing any of this. But if they did, for whatever reason that I can't understand, they had the name first. So all that they would be doing is exactly what this says, right? Seeing that the familial connections all have this same name in common, the name you already have. Again, this is not how this is supposed to work. It just doesn't make any sense. The FBI then sent local law enforcement a tip to investigate defendant. Now, right here, we looked at these. We already just covered, the search warrants, right? And the probable cause affidavits and all that. This makes no sense because they were already investigating him long before. Okay. The IGG now here's where they have to distance themselves from it. Like we relied upon it, but we didn't need it type thing. And again, that's part of why there's confusion. The IGG process pointed law enforcement toward defendant, but did not provide law enforcement with substantive evidence of guilt. Well, of course it didn't. The FBI did not, for example, conduct a direct comparison. that type of direct comparison required the more traditional DNA. Of course, that what they're saying is that, like when they get a buccal swab. Prior to the FBI's IGG efforts, the ISP laboratory developed this traditional profile from the knife sheath. After identification of the defendant, again, they had already identified him. Law enforcement, this is, and again, the trash. I've been thinking about this, guys, and even in my sleep. I'm not even joking. And the same question that I have that I've already voiced in a number of different ways, I had the same question about the trash, right? Because again, they already had the name, right? Remember, they did the dad trash before they had the search warrants. So if they had the name, and if the Elantra and the bushy eyebrows and whatever else they had that is not DNA related, right? Not DNA, not IGG, right? If they already had that stuff and they weren't waiting on DNA for the search warrants, why is it that they even bothered with the IG, but also why is it that they bothered with the dad trash? Because remember, this is the thing. They served that search warrant at the parents' house. It was like mere hours after, or like almost immediately after getting the dad trash. It was like the next day. They got the dad trash and then they served the search warrant on the house. So again, even if they're saying they aren't relying on it, this is why it's so weird. It's like it's almost like they were relying on it, but they want to say they weren't. I don't know. I haven't even been looking at the chat, but this is just a lot. So yeah, I mean, I'm not, oh, okay. I see what's going on here. Yeah. So there's a lot of, okay, to answer this question, there's a lot of misinformation. Okay. You know, while I am not an attorney, right? You know, I do have training and experience, and I'm working towards that goal at some point, but okay. I prefer, especially when it's like something like this, where it's pre-trial, you know, I try to employ the same methods as the law tubers, right? Which is relying upon court filings, because anybody can say anything online, right? And while that's true with everything, and rumors can be true with everything, that is, I would say, especially true with this case, right? Where there's a lot of misinformation and there's really no way to validate it. Now, I understand what some of you guys are saying, that maybe some of these court documents are not reliable. Okay, but here's the thing. If that's the case, then his defense attorneys are discovered, like that's what they are. That's kind of what they're saying, right? In the motions to suppress and in the Frank's hearing, they're voicing the problems that they've seen after looking at the discovery. Now, what's the difference between them and people online? They have the discovery, we don't, right? Anybody on, like, only the attorneys have the discovery. So they have the discovery, okay? And so you better believe that if there's a problem with any of it, they're going to voice that, okay? And we've seen them, they're doing that. They are doing that. I'm not worried, right? I'm not worried. They are in a better position than we are. Anybody who's not an attorney in the case, they are in a better position to notice any errors and, you know, all that, first of all. Second of all, because this is a court case, right, that's headed for trial, anything that's going to impact the outcome of this pretrial litigation or the trial itself is going to come from the court filings, because guess what? They are not basing things on. They're not basing things on rumors online or whatever. Like, that might come up in voir dire for the jury, right? Like, we've already seen a little bit of that, but that's not relevant to the people involved in this case, to the attorneys, right? So hopefully that makes sense. Right. I mean, I agree, Flash. I agree about what you're saying, that where does that get us? I totally agree with that. I mean, again, we have to remember, guys, his attorneys have the discovery and they are working really hard to find problems. And, you know, they are in the best position. And again, I have to just reiterate, even if this is unreliable, even if anything in these court filings, or let's say the affidavits, the PCAs, if any of that is unreliable or dishonest or incorrect, that's what these motions to suppress are for. And that's what this Frank's hearing is for. His attorneys are handling it. So when you compare that to like statements made online by random people, that there's less of a way for that to be vetted, if that makes sense, right? So like worst case, if you go with the worst case scenario and say that any of these court documents are fabricated or whatever, right? If you go with that being a worst case scenario, you still have his attorneys who have all the discovery who are going to handle it, right? And then again, if you compare that to like just random people online, you don't even have that. So hopefully that makes sense. I mean, you might say everything is sealed, but the vast majority is unsealed. I know because I'm covering all of it. I would say for each, I don't know, 20 court filings on the docket, maybe one of them are under seal, if that. So while it feels like things, I mean, yes, important things are under seal, things we wish we had, but in terms of the statistic wise, the vast majority is not under seal, let alone everything. The vast majority is not under seal. It's just certain specific things that are, you know, again, especially as it relates to IG, but we're going to see, I've got all these documents pulled up that are not under seal, obviously, and they all deal with IGG and DNA, and there's quite a number of them. So, okay. After identification of the defendant, law enforcement recovered trash from the home of the defendant's parents and ISP laboratory. Analysis of items from the trash for comparison to the unknown. Right, this. They wanted to analyze the trash for comparison to the unknown crime scene DNA. Again, I don't know why this is necessary if you already had the name, and then furthermore, now you have this lead from the IGG, supposedly. The comparison indicated the DNA found on the trash belonged to the biological father of the individual who left the DNA at the K-bar knife sheath. Okay, so then there's a footnote for this. I thought it was going to explain how they determined that. Instead, it says STR analysis is routinely used for kinship. Okay. Pursuant to a search warrant. All right. This is what I'm saying, people. This is what I'm saying. Pursuant to a search warrant, law enforcement then collected DNA. Remember, this is what I'm saying. After they got the trash DNA. That's why the trash DNA matters, right? The trash DNA. So to say that they didn't rely on IGG for these search warrants, I don't see how that is the case. Again, it seems like they didn't really need to, but like they're saying they did. But then they're trying to say they didn't. That's what this looks like to me because of the order of events, right? Again, like I said, once they got the dad DNA from the trash, after that, then they served the search warrant, the real deal search warrants, you know, and they attacked him at his house and, you know, ambushed him at the house. You know, we've heard all that. And then, of course, then we know that there's a really high match. This is just interesting to me. The genealogy conducted by the FBI resulted in a lead that pointed law enforcement to defendant. I don't what this is leaving out entirely is the bit with the car, right? It's leaving that out, which we just covered in the affidavit, probable cause affidavit. Pointed law enforcement to defendant, but it did not result in the creation of many documents or records. This is where it gets really interesting. Listen up, people. Much of the information relied on by the FBI was only viewed through the user portal in the publicly available genetic genealogy services. The FBI did not download or create copies of those records. Once the defendant was in custody, the FBI removed the SNAP profile from the genetic genealogy services. This means the FBI no longer has access to view much of the information it used to create the family tree and cannot view it again without resubmitting the SNAP profile to the genetic genealogy services. To the state's knowledge, the only records that reflect the FBI's efforts to create defendant's family tree is the family tree itself. Notes jotted down by FBI agents as they constructed the family tree, and any records created to document the removal of the SNAP profile from the genetic genealogy services. So remember how there was a lot of back and forth at this time about they kept saying, the defense kept saying, can we see it? Can we see it? And they kept saying, we don't have it. The FBI has it. And that was going on for months and months and months. Now, come to find out in this document that the FBI didn't save any of their work. Of all the things so far in this live stream that we've talked about with this is the most challenging for me personally to believe Remember, we even talked about it earlier today with Karen Reed, but it pertains to other cases, right? Showing your work. This is like being a kid in school and you have a math problem, right? And like a long division or whatever, and you just give the answer and you don't show your work. It's like, no. You have to show your work. I don't even have the words. Yeah, I mean, that's true. Yeah. Hi, Franks. Shout out to Franks. Yeah, so this is the most craziest, this is the craziest thing of all, right? That the FBI doesn't have any of this. Like, I don't I just don't find that plausible, guys. I hate to say that. I hate to say that. But after covering enough trials, and man, especially recently, right? The FBI has been all up in the Casey Anthony trial like no other. I mean, it's just, this just doesn't, I just don't, I don't see how this could be possible. I just don't see how this could be possible. Like, this is odd. Like, if the records don't exist, it just, I don't think the FBI, okay. My gut would be not that the FBI had it and deleted it. It would be that there aren't records. Probably. I don't know. Because I just don't see how that could happen, right? I just don't see how that could happen. We know there's so much oversight. I mean, again, in Casey Anthony specifically, we've heard about it. There's so much oversight and so much like checking and triple checking and quadruple checking, quality assurance. I mean, I'm sure there's even more now than there was then. So this just, and remember, initially, again, remember, guys, initially the state kept saying the FBI has it, but they haven't turned it over. That's what they said for a really long time. So this was the first time in chronological order, right? This is June of 2023. This was the first time this was said. This was new information, different from before, about the FBI doesn't have it. They don't save it. They didn't, or well, it doesn't even say that it's not their protocol. It just says they didn't save it. It doesn't even explain the protocol about it, right? It skips over that. I mean, at least if you're going to say this, include something to be like, their protocol is to delete it, or their protocol is to not save it, or whatever. But okay. Argument. Okay. They want to protect the names in the IGG. I mean, again, I feel like what they're talking about is not the issue. Like, they're talking about the names of the family member. Like, I feel like this is all immaterial, right? Like, how do you, it's like, that's not the problem here. Dear God. But again, the defense is asking for the names because they're trying to see how this happened. Rule 16A. Let me see what else is in this document, because we have other documents to get to here. We might come back to this. Let me move to the next one. Because he's just going to be citing a lot of case law that says they don't have to, or saying that they should protect people's names. And again, like, I get why that's relevant to like keeping people's names private, but like, that's not why we're covering these, right? We're trying to figure out what the dealio is. Okay, so this is, again, we're going in chronological order. So this is from June 22nd, 2023. Yeah, I agree, Flash. Well, so the FBI says they don't have it, though. There's a big difference. I mean, the state would be better off saying, hey, the FBI is still not handing it over, right? Because then there's process for that to force that, right? That TUI process. They're saying they don't have it to hand over. It's very different than having it and choosing not to hand over. Again, because there's a solution to that. Okay. So here's a declaration of Ann Taylor in support of the defendant's third motion to compel. After reviewing materials provided, the following remains to be discovered. A, request 3 profiles uploaded to a DNA database. The state has provided information related to this quest for the seized item, the knife sheath only. Okay. Right. Okay. Part of the third supplemental discovery request was for materials related to genetic genealogy testing. The state has objected to this request in its entirety and has filed a motion for a protective order. That's what we just read. Counsel for Mr. Kohberger requests this order consider the contemporaneous objection to the state's motion and declarations. Okay. Counsel for Mr. Kohberger has reviewed the materials provided in this case regarding the DNA testing. Further, experts in the field of genetic genealogy and DNA have consulted and offered information and guidance. The state acknowledges it used genetic genealogy testing in this case, but claims it does not have to produce the records in the specific request for discovery. The defense disagrees. Counsel has learned through consultation with experts and sources referenced below that the use of genetic genealogy databases does not necessarily lead to a single individual as a potential suspect, and that reports of these searches often reference multiple individuals for further investigation DNA testing. And in fact, the state says hundreds of relatives. Genetic genealogy labs do not generate a profile in the same way that forensic labs do, and there therefore cannot be a direct comparison. Okay, based upon information from experts in the field, I have learned that once a genetic genealogy profile is created and testing by the private lab is completed, the profile is uploaded to a database that contains similar DNA from other individuals. Once the genetic genealogy profile is uploaded, the profile is compared within the database and relatives are identified. It is my understanding that once possible relatives have been identified, their identities are used to construct a family tree to identify possible suspects using public records, and in some instances, contacting individuals. This leads to a pool of individuals rather than one individual. The timing and steps utilized are extremely important to Mr. Kohberger's case, investigation, and defense. Okay. If a suspect is identified, the agency is required to retain all. Well, here you go. Look at this, people. This is from the DOJ. This relates directly to the FBI deleting all their work. If a suspect is identified, the agency is required to retain all FGG profiles, account information, and data for potential use during prosecution. I mean, again, that's common sense, but there it is. And it has an attached exhibit. So FGG, by the way, is basically synonymous with IGG. I looked this up earlier. That's forensic genetic genealogy. It's basically considered to be synonymous with IGG. So when you see this, just you can think of it as IGG. New York Times article. Okay, so then these are going to be these exhibits. So what does this say? Okay, so this is the DOJ. Okay, so this would apply to the FBI, right, guys? So, all right, here we go. Remember when I was like, remember how I complained about the state? I'm like, they didn't even include the protocol. We need to know what the protocol is. Well, the defense included the protocol. Okay. I'm just looking for the relevant parts here. Where it applies to. There's CODIS. Okay. And this is exactly what I said. Remember when I said also during the state's motion, I said how the FBI does not themselves build a family tree. Remember how I said that? Literally. They vendor laboratories to perform it. After a reference sample is genotyped by vendor laboratory. Like I said, I literally said that. Then they give back the case. It is important to note that personal genetic information is not transferred, retrieved, downloaded, or retained by GG service users, including law enforcement, during the automated search and comparison process. In addition, the investigative use of FGGS involves different DNA technologies, genetic things, and databases that were used by CODIS. Information data derived from FGGS is not and cannot be uploaded, searched, or retained in a CODIS DNA index. Okay. A genetic association means that the donor of the forensic or reference sample may be related to a service user. However, information derived from genetic associations is used by law enforcement only as an investigative lead. Traditional genealogy research and other investigative work is needed to determine the true nature of any genetic association. A suspect shall not be arrested. Here we go. So based solely on a genetic association generated by a GG service. If a suspect is identified after a genetic association has occurred, STR DNA typing must be performed and the suspect's STR DNA profile must be directly compared to the forensic profile previously uploaded to CODIS. This comparison is necessary to confirm that the forensic sample could have originated from the suspect. Investigative collaboration. After consulting with the DLO, the investigative agency shall contact the prosecutor. The investigative agency shall advise the prosecutor of the nature and status of the investigation and results of the DLO's evaluation of the candidate forensic sample. After discussing these issues and based on the information provided, the prosecutor and the investigative agency must agree that the candidate forensic sample is suitable for FGG and that it is an appropriate step. Investigative caution. Investigative agencies shall identify themselves as law enforcement to GD services and enter and search FGG profiles only. Now, in the hearing where they bring the people in to talk, we know that this is not always the case and they don't always follow the rules. Investigative. Again, they don't always seem to get the consent that they're supposed to. Again, I brushed up on these just over the past couple of days and watched that hearing. Wow. If that determination is made, the investigative agency shall consult with and receive approval from the prosecutor before covertly collecting any reference samples that will be used. Well, you know what that sounds like? That sounds like the dad trash. By investigative. Again, it says the same thing again here. Only used to generate investigative leads. Okay. All FGG profiles and GG service account information and data shall be treated as confidential government information consistent with any applicable laws, regulations, policies, and procedures. If a suspect is arrested and charged with a criminal offense while FGG is in progress, the investigative agency shall promptly contact the relevant vendor. That's if it's still in progress. Okay, if a suspect is arrested and charged with a criminal offense after an FGG profile has been entered into one or more DTC services, the investigative agency shall make a prompt formal request that all FGG profiles and associated account information and data held by any such service be removed from its records and provided directly to the investigative agency. The investigative agency shall document its request in compliance by the DTC services. All FGG profiles, account information, and data shall be retained by the investigative agency for potential use during prosecution and subsequent judicial proceedings. If a suspect is arrested and charged with a criminal offense after an FGG profile has been entered into open data personal genomics DNA database, The investigative agency shall promptly remove the FGG profile and all associated account information and data from the database. Now that means from the database, like for example, like a 23andMe. The investigative agency shall document the removal of this information and data. It shall be retained by the investigative agency. There it is, bam. So they have to remove it from the database, right? Because that makes sense. It's like a consumer database, right? But it should be retained by the investigative agency for potential use during prosecution and subsequent judicial proceedings. Y'all, oh my God. And I'm sorry I haven't been able to look at the chat, but Flash, I've got your back. I am with you 100% about misinformation not being spread, and I appreciate it. So hopefully everybody here understands the importance of that. I know it's hard because there's things that we don't know, and some of these documents are under seal, but the best we can do, again, if this was something else that wasn't a trial, right? Let's say that, I don't know, pick anything else. Pick something that's just like, whatever, some story in the news, celebrity story, I don't know. But it wasn't like a criminal trial, then yes, court documents would not be the place to go because it would be irrelevant, right? But when we're talking about a criminal trial, then in terms of things that are going to relate to that, it's going to be what we're looking at here, right? That's as it pertains to the trial. So, it looks like, according to this, they should have kept, I mean, again, common sense, of course they have to keep it, right? They have to show their work, but it looks like they didn't. Well, according to Bill Thompson, I mean, you know, they're going to have to, well, I'm sure they will or did already, but the defense, I would imagine, is going to have to bring in the people from the FBI and have them under oath talk about what they did and did not save and question them about it because, yeah. Okay. I'm sure that they, you know, that's probably already happened at one of the hearings that were not open to the public. Okay, so let's see. I'm not too worried about it. Okay, let's move on to the next one. So making our way through. So now we are on, where are we? We are now July 5th, 2023. Okay, people. State's response to defendant's third motion to compel discovery. So now we're back to the state. Okay, what's the state going to say? This one's short, luckily. That's just a bunch of, they're incorporating it, whatever. As outlined in that motion, the state seeks an order protecting IGG information from disclosure as it falls outside the purview of Rule 16. Again, I'm like, you're missing the real problem here, Mr. Thompson, in my opinion. The alternative, if the defense can establish that IGG information is relevant, the state asks the court to conduct an in-camera hearing so the state can present information related to the IGG information and or a protective order pursuant to ICR. The state will continue to, okay, that was useless. Next one. Okay. Reply in support of motion for protective order. Let me zoom in. Okay, here's the state again. State's back. State is back again. So this is from July 14th, 2023. The state submits its reply to address several of the defendant's arguments. Okay. As well as two declarations. All right, so what are they going to say? So A, defendant has not demonstrated that any subsection of Rule 16 requires the disclosure of IGG information. Rule 16 contains, and we've covered Rule 16 in depth on this channel as well, contains several discrete categories of information the state must disclose to the defendant in a criminal case. By the way, Rule 16 is an administrative rule in Idaho. And there's like a lot of subsections, and like that's why we hear it talked about a whole lot. Showing substantial need in the preparation of the defendant's case, and that defendant is unable without undue hardship to obtain the substantial equivalent by other means. Now, what hasn't come up yet in this back and forth is that they need it in order to see if the search warrants are valid. But that's where we're kind of at now, okay? Although actually, I guess they've actually seen it and they're saying the search warrants are invalid, according to the defense. The state explained in its motion why all these subsections do not apply. Defendant objects. Defendant's assertions do not withstand scrutiny. First, defendant baldly asserts that the IGG information rather obviously falls within the ambit of Rule 16b-4. Again, material to the defense are intended for use by the prosecutor's evidence at trial. Now, we already know they don't intend to use it at trial. That's, you know, were obtained from the defendant or belong to the defendant. So that also wouldn't be really relevant here. The thing that would be relevant is this one, material to the preparation of the defense. Now, again, here's the thing. Why, potentially, okay, if I try to think of this logically, perhaps the reason why they keep saying it's not material to the defense because we're not going to use it at trial is because they're not going to use it at trial. However, that fails to acknowledge that the preparation of the defense might not just be trial strategy, right? Again, look at where we're at now with these motions to suppress. The preparation of the defense also includes things like motions to suppress, right? Just saying. The state is at a loss as to how that theory supports a claim that the IGG. What? I mean, I don't see how you can argue that it's not material. I mean, I don't really see how you can, again, even just from what I just said, right? Because it's clear when you look at the order of events, it's clear that they did. Again, it looks like they didn't need to rely on it, but they did rely on it, which is why it's weird in terms of getting the search warrants. If defendant wishes to explore the theory that his DNA was planted on the K-bar knife sheath, he's free to do so. I don't even know if that's what they're getting at, but whatever. But the family tree created by the FBI has no relevance to that theory. I feel like this is like a straw man argument. Next, defendant attacks an argument that the state never made. He claims the state argues that if the later SDR testing is accurate, then there is no reason to concern ourselves with how the state came to investigate Mr. Kohberger. But for the purposes of this motion, the accuracy of the testing is beside the point. What? This is just going to drive me insane. As demonstrated from the figure below, these are different processes. So, I'm not a DNA wizard. This is not, I don't know. We need a DNA wizard in the chat that can explain what the significance is of all this. I could probably sit here and delve into all this, but again, part of the problem is like some of this stuff doesn't make sense from the get-go in terms of the timing of it. Anyway, okay. I feel like it would be the type of thing where it's like you'd be looking at it and you're like, wait a second, I'm trying to make it make sense and it's not making sense. Defendant criticizes as puzzling the state's assertion that B5 does not require the state to disclose what investigators do with the results or reports from specific efforts. Far from puzzling, that conclusion is compelled by the plain language of the rule, which simply requires the disclosure of the results or reports themselves. Under defendant's novel theory, wow, there's a lot of strong language in this document. I don't know if have you guys been asking me questions? So here's the thing. I've got another screen up and I'm reading these documents. So I'm scrolling back over the chat. I have been missing things left and right. It's a lot harder when I'm reading documents versus like having a hearing or a trial playing where I can read both at the same time or see it at the same time. But I'm looking at the documents, so I'm not seeing the chat. So let me see what you guys are saying. And I'm sorry if I'm behind. I'm sure I'm behind. Okay, so as to this, it does need to be deleted from the consumer DNA or for the consumer database website. But the part that you're missing is that the FBI, as per the DOJ thing we just read not that long ago, they have to still save it. It's just that they have to take it off of the consumer website. So it does need to be saved. It needs to be saved by the FBI and given to the prosecution. Hopefully that makes sense. And shout out to American Princess. Welcome. Glad you're here. I have watched, if this question is for me, I have watched everything and read every document in this case since it first started. And if the November 2nd IGG hearing, is that the one I have pulled up? The one I have pulled up in case we want to watch it is the one where they actually bring in like experts, if you will. I don't remember what date that's from. It might be from November 2nd. But I've watched every single hearing, and we can pull up any of these and watch them too if it's a different one. I don't know what was too soon. I don't know what was too soon. I'm sure we already read this because we've been going in chronological order. The state reserves the right to present the IGG motion. at trial if the court requires the state to disclose. They reserve the right. The state reserves the right to present the IGG information. I mean, everything that I've seen, and let me just be clear, everything that I've done a lot of research in preparation for this, and beyond what they've been saying, as in these two parties, right, about it not being used at trial, everything that I've seen, and we're going to get into this. I've got a website ready to go here. Says that it's not admissible. It's never been used in trial. It's like not admissible at trial. Whether the state wanted to or not, I don't think it's allowed from everything I've seen. Oh, that's the August one. So you were referencing I mean, yes, I have watched it. I don't remember specifically because again, and I don't think I was covering it at the time, but yeah, I did watch it. November. Okay. We can definitely watch that. I can add that to my queue. I just don't remember off the top of my head which one that was because there's been so many. Franks, I appreciate that. Thank you, Franks. Frank says you can watch any myriad of channels for speculation. Chelsea says stick the documents or the facts. Thank you. I appreciate that. Yeah. That is what I endeavor to do for sure. So yeah. Well, you guys are so kind. Thank you. You guys, I appreciate y'all. Okay. So, and I will say this much, that I don't know, I can't say for sure that maybe Bill Thompson didn't want to use the IGG at trial because this came up really early on. It seems like maybe what happened was he learned that he couldn't, and then he said he didn't intend to. But that is, I will just say that is a personal opinion based on, again, there was so much, like the DNA on the knife sheath. Y'all remember, like, think about it this way, right? Small town law enforcement, small town, prosecution office. And like, I feel like they, for them, it seems like they felt like they hit the jackpot when they got that knife sheath, right? And so then there was so much talk about the DNA. And I think that that's probably part of what is going on here. Like, I wonder if they didn't just work themselves up into a predicament because they really wanted to talk about the DNA. And then I wouldn't be surprised. This is just my personal opinion. I wouldn't be surprised if at some point the term IGG got thrown in on accident, or whatever from somebody in the office, because DNA is 3 letters, IGG. I mean, it could, I'm just saying, right? Like it could have just been like, and because it's such a buzzword and it's such like a common thing you hear about, anytime you hear about DNA, you hear about IGG. I wouldn't be surprised if it started out as like somebody said it. And then I don't know, I could just see how this could have maybe snowballed where that seemed like the right thing to say. And then you learned it was not the right thing to say. But we'll keep reading. And before we, anyway, okay. So, all right. And that's why I am very careful too. If I do try to give any type of like opinion or whatever, I always say so because, again, the point is I want us all to take a look at this and everyone determine for themselves what they think it means. So, okay. Under defendants, this is where we were. Under defendants novel theory, this subsection would require the state to disclose everything down the investigative stream for a scientific experiment from a scientific experiment, regardless of its relevance at trial. I will say, if you're in 4th grade at school and you have to if you participate in the science fair and you're going to do a scientific experiment, how far do you guys think you would get if you don't show your work, right? If you're doing the science fair and you're trying to prove a hypothesis or disprove a hypothesis and you don't show your work, how are you going to do? How well will you fare in that? Let me know. I don't know. He's missing the point. Defendant does not have a constitutional right to discover all aspects of the investigation. Ugh. I mean, I don't like the way that sounds, but I get it. But defendant contends that a massive investigation came to focus on him and him alone and asserts that he has a right to discover the investigation that led to him. This right here is exactly the heart of where we're still at with the question of how did they come to him. In these motions to suppress, they're still asking that question. And they're giving a rhetorical answer, they as in the defense, which is the IGG. That's what they're saying. But again, to me, this is really confusing because it looks like the car. But also, they made such a big deal about the IGG and the DNA that, again, this is where I keep coming back to. It looks like they did use it, but they're being wishy-washy about it. Like, I don't know. It's like plausible deniability in a way. Am I making any sense? It's hard to... Okay, let's just keep reading. The context of his claim suggests he is asserting a constitutional right to discover anything and everything related to the investigation, but his asserted right finds no support in the decisions of the Idaho Supreme Court or the U.S. Supreme Court. Okay. The court can use the process explained in the state's motion to verify the IGG information does not contain exculpatory evidence. Well, okay. Though a criminal defendant has a constitutional right to discovery, that right is not infinite and does not encompass the IGG information. I'm face palming. Can you guys hear me face palming? I'm literally smacking my hand against my head. You see what I mean? Again, you throw that word in and now it's like, oh, well, now it's exempted, right? Y'all, okay. How many times have we heard about this? Recent example, Baldwin, right? It is not the state's job to determine what is exculpatory and what isn't, and what is material to the defense, what isn't. It is the defense attorney's job because only they can know what they need, and they don't know until they see it. And the fact, it's like just a blanket statement. It doesn't encompass the IGG information, doesn't even specify what. Due process requires all material exculpatory evidence known to the state or in its possession to be. This is why, this is the thing. I have to just say this about discovery, right? Because again, we know this to be the case. Due process, you have to turn it over, right? If it's exculpatory. But I do think that Baldwin brought up an important point, which is, how does it make any sense for the state to determine what's exculpatory, right? Like Florida, of all the things and all the things going on in Florida and all the craziness and whatever going on in Florida, I'll say it, I've said it before, I'll say it again. One thing that Florida does right is the way they handle discovery and the way they handle like the sunshine laws, like everything is open, you know, public access to information, right? But also the discovery process, because you do not hide the ball there in discovery. And while there might be some other fuckery going on, one thing that does not happen is like hiding discovery, at least for the vast majority of the time, right? I mean, it's just a thing. So you get it, you turn it over. I mean, even in Karen Reed, man, right? With the new special prosecutor, Hank Brennan, we heard in the first hearing him saying, if I get an email, I turn it over, right? If I get this and that thing, I don't even know what it means, I turn it over. And that's why you do that. That's why you do that. Let them decide what is exculpatory, what is important, what they need and what they don't need, right? Bryan Engines. Okay. I know. I agree. Yeah. So as soon as I was saying that, I was trying to remember what discovery were they trying to hide? I guess it was, well, yeah. I mean, kind of similar to the FBI not saving their work, right? The fact that they didn't, I would say that as far as the discovery there, the fact that they didn't record that interview with Kimmy, again, it didn't exist, so they can't turn it over. But they're really an anomaly, I'll be honest. In Florida, they're an anomaly because you really don't see that type of conduct in Florida, really. I've never have anyway. Yeah, the statements. Yeah, yeah. So I'm not sure what you're referencing here, though. I can't recall about on Bryan Enton's X page. Was it about the hearing? Right. Yeah. Yeah. For anyone who is not familiar, I do have a playlist on my channel for the Shannon Gardner case. We're almost caught up because I just started covering it recently. We've been doing like going through in chronological order. It is something else, really something else. Yeah, really something else. I've never seen anything like it's its own category, really. It is only fire and only spice and only tea. All of the drama, all of the spice, all of the tea. Oh, I see. Thank you for clarifying. Interesting. I wonder how that would be. because, I mean, and I, by the way, shout out to Bryan Enton. I freaking love Bryan Enton. I'm curious as to how he would have it. But I totally trust him completely. Like, I mean, you know, it's just surprising that if it was public, but I will definitely see what I can find. And if we need to find it on Bryan. Now, I'm not a member of X, or I don't know if you have to be, but anyway, member of X. Is that even the right word? Anyway, okay. So the court can use the process explaining the state's motion to verify the IGG right. This is where we were. Yes, the exculpatory evidence, right. And as the state explained in its motion, the IGG information is neither exculpatory nor material to guilt or punishment. What? Guilt or punishment? Y'all, help. What did they mean to say here? Innocence? That still seems like not the right word. I mean, and that's not even the standard, right? It's not just like, does this absolutely prove someone's guilty or whatever? Like, no, things can be material to the defense that go well beyond that. Oh my God. Okay. Family tree built by the FBI merely pointed law enforcement to the defendant, and law enforcement followed that lead to develop the substantive evidence of guilt. Again, if you read the probable cause affidavits, it's the car. I'm going to pull my hair out, you guys. Defendant theorizes that the IGG processes was like a lineup where the government was already aware of who they wanted to target. Well, again, this is where this comes in, okay? Remember, like I said at the very beginning of this live stream, the point of the IGG, and when you use it, is when you don't have a name. Key thing, when you don't have a name. So you start with the unknown DNA sample, and you need to get to a name, okay? Remember, they had the name first. So what I have to wonder, and the only thing that would make sense if they used IGG at all, the only thing that would make sense is if we know they already had the name from the car, but that they used IGG, I'm putting this in air quotes because this isn't how it's supposed to be done, where they actually put the name in or something along those lines. Like they did it backwards instead of starting with an unknown sample to get to a name. And that would make sense with what this is saying, because they had the name first. Again, it says here, the state has no plans to use the IGG information to prove defendant's guilt. They're completely skipping over what we're seeing now, which is that guilt be damned. What about the search warrants, right? Moreover, now they're going to reference the DOJ policy. As the DOJ policy on IGG explains, the FBI can only use IGG after the investigating agency has pursued reasonable investigative leads to solve the case. And no, that's not what it said. What it said was once they have the lead. We read this. I don't want to go pull it back up, but I feel like this must be taking out of context to a specific part, because that is not at all what I read, and you guys would see it on the screen. It was the opposite. Like, oh my God. Okay. Again, guilt or punishment. Weird. Are they like fixated on the book Crime and Punishment? Like, what is happening? If the court finds that the IGG information is relevant to guilt or punishment, the state is simply asking for an opportunity to provide additional information to the court in camera. So the court, now we do know that this happened, this in-camera hearing. We do know that this happened. There's been more than one, right? But it was we know that he said to turn it over. So that has happened. And I'm sure I've got that pulled up in one of my tabs. The declaration submitted by the defendant do not make the IGG information discoverable. Oh my God. Look at this. Declaration of Bicka Barlow. I think she was one of the people who testified at the hearing. The court should disregard Barlow's declaration as a poorly disguised legal brief. Wow. Submitted by a lawyer who is not counsel of record in the case. It is now well established in Idaho that testimony containing conclusions of law by an expert witness is generally inadmissible. Setting aside the improper nature of Barlow's declaration, the declaration contains two primary assertions. Neither of the assertions support the defendant's attempt to discover the IGG information. First, Barlow suggests the IGG information in this case could give defendant additional investigative leads because, quote, scare quotes, in some instances, the IGG process leads to a pool of individuals rather than one specific individual. She provides several examples of other cases where individuals supposedly had to contact individuals for further family information to narrow down the pool to a single individual. Again, Because this is how it's normally used or supposed to be used, where you start, again, unknown DNA sample, and you work your way down to get to a name. Again, seems it doesn't apply here. But the fact that investigators had to contact family members in other cases to develop the tip that led law enforcement to the defendant does not mean the FBI had to do so in this case. Hang on, stop everything. Wait, what? Y'all. Is he suggesting that law enforcement did not need to build a family tree? Because remember what they said? Hold on. I will just say for you guys, I have a good memory. That's what all the 30,000 trillion years of violin will do for you. Look, it's right here in the first paragraph. Guys, look. The FBI then used common genealogical techniques to develop a family tree leading to the defendant. And all of the names, remember all these names of the innocent relatives, quote unquote? Family tree. Look. Family tree. Now let me go back to where we were. But the fact that the investigators had to contact family members in other cases to develop the tip that led law enforcement to the defendant does not mean the FBI had to do so in this case. One more time for fun. Is it fun? I hope. Horror? I don't know. One more time. The FBI then used common genealogical techniques to develop a family tree leading to the defendant. This is okay. You guys, of all of the things, what is good about this is it needs no explaining because it's point blank. You can see point blank. Like the words are, this is the state, like back to back. And what are we difference in time here? This is June 16th. Okay. I'm going to highlight it again right here. June 16th. Okay. Now this is, what is this? July 14th, less than a month. I have no words. And when I have no words, sometimes there's only one thing that can be done, and that is to goat. I haven't goated in a while. This is really sad, honestly, sad. If I start talking about this, we'll be here for a long time about my thoughts on this. Okay. Do you guys see this? I don't. In June, the FBI built a family tree. Again, remember what I even said at the time when I read that. I said, well, from everything I've learned, they don't actually do that, right? It's the third party that they hire. But anyway, nonetheless, who cares? What I can just impeach him with what he's saying, right? He says, Bill Thompson says, that the FBI built out a family tree, right? And then here, it says they didn't. Can you imagine being a defense attorney and dealing with this? What do you even say? What do you even do? Like, what else is in here? I'm so mad right now, guys. Now they're going to attack this one. The thrust of Mercer's declaration is that the state should be required to disclose the IGG information because under the ABA standards for criminal justice, defense attorneys have the duty to investigate. But the standard he cites belies his claim. I feel like it must take a lot of guts, though, to like make these assertions that like under the, you've got the ABA standards for criminal justice with something as basic and standard as that, like the defense attorney's duty, right? The duty to investigate, right? Like, so that it's not ineffective assistance of counsel. And it takes a lot of guts to then be like, nah. But instead indicates that the defense attorney's investigation should include efforts to secure information in the possession of the prosecution and law enforcement. I need to drink some water. I feel like I'm gonna pass out, dude. Oh my God. And there's the conclusion. I feel like this is like weird. This is weird. This is weird and really. And again, like I said, at the time when these were happening, there were like 50 quadrillion things coming out. Again, it was all the stuff about the cameras in the courtroom, all the stuff about the alibi. And some of this stuff I think was missed because again, I was not covering this at the time, but even if for people that were covering it, there was so much, right? That some of these little important details, I think, I mean, I know I didn't hear about them, at least not all of them. Why are they, wait. Why are they including something from Sacramento, California? What? Okay, I'm just going to say, whatever this is, doesn't matter. What happens in California stays in California, people. It has literally no bearing whatsoever in Idaho. It is not binding authority. It is what you call persuasive authority, which means the court can consider it, but it literally, essentially, it's completely irrelevant. Okay, great. Next one. Y'all. Oh, that's odd. Huh, what? Maybe that's a typo? Yeah, so the healthcare case, I wouldn't mind just talking about something else for a second because this is like, yeah, that is in New York, and New York does not allow cameras. And they just upgraded the charges there. The grand jury indicted him with first degree. Now, we did cover, when this whole thing first broke, we did cover the difference between first and second degree in New York because it's very specific and it's different than other states. And that we went through all the different, like, if you will, aggravators, right? Like in states that have the death penalty, things that would be considered like aggravators are what are a part of the first degree murder statute in New York just to get first degree because, you know, they don't have the death penalty. It's like basically almost all of the murders, right, are going to be second degree. Like you have to do one of these other extra things to be first degree. And we went through them all and I was like, I don't know that any of these would apply. And I don't remember what I said about the terrorism one. I probably said, oh, it won't apply. But again, that was when this first broke and it was before the fallout. Now, in hindsight, now that has happened, I can see how that happened, like how the terrorism, because initially it wouldn't have been so obvious, but now with all the people who've been doing the things, like, you know, you guys know, it does seem now, who knows if that was his goal? Now that's going to be for a jury to decide if it gets there, but one could see how a grand jury could get that far via the terrorism, but that was the only one that would have been applicable for him. So, okay, now finally, judge's order. Okay, so now we're on 10/25/23, October 25th, 2 days after my birthday. Order addressing IGG DNA and order for in-camera review. So here, judge is going to try to make sense of all this. What's he going to say? I mean, even here, he says the FBI employed the use of IGG on DNA located on the knife sheath. Again, y'all, from what Bill Thompson just said, through the IGG process, the FBI constructed a family tree of individuals whose DNA matched with the DNA found on the knife sheath. Now, yes. However, sometimes Bill Thompson has said that, and other times he's said literally the opposite. So I don't know. The FBI then sent local law enforcement a tip to investigate Bryan Kohberger. Again, they already had the name from the car. Nothing about law enforcement's use of IGG was used to obtain the arrest warrant for Kohberger or to abstain. Okay, now again, here's the thing. I have to push back on this because this is where the plausible deniability comes in, because it's very clear. We covered this already. I pulled up a specific example on the last Kohberger live stream of where they talk directly about the DNA with the knife sheath. Now, they don't say IGG, but they say DNA in the knife sheath, and they talk about a couple other things, and they say the trash. And all of this is in the, it was from the Washington probable cause affidavit. And it's like, maybe they didn't say IGG, but why are you including any of this if literally it's not, like, this was the search warrant. It's in the search warrant. Like, why would you be mentioning it if it's not used, right? It doesn't, it's almost like saying IGG without saying IGG. That's what it looks like to me. The state has now filed a motion to prevent the disclosure. Disclosure of information gathered from an IGG investigation is an issue of first impression in Idaho. The state claims that the IGG information was not used to obtain any warrant and will not be used at trial. Okay, won't be used at trial, but the warrant thing, man, I'm just to reiterate, it seems like it didn't need to be used if they just needed the name. Now, the problem is this, right? That's not going to get, having a name is not probable cause. This is where it's like they want to have both sides, right? Because they need probable cause, but they have to show that they had probable cause without having the DNA and the IGG. However, in their probable cause affidavit, it's all up in there. So go figure, right? For the reasons set forth below, the court finds that the defense is likely entitled to see at least some of the information from the IGG investigation, even if it may ultimately be found to have no relevance to the defense. However, because the court has not seen exactly what information pertaining to the use of IGG is available, the court cannot precisely say what should and what should not be disclosed at this time. Because of this uncertainty, the court grants the state's request for an in-camera review. Here's the background. Button snap, sheath thing, you guys know. They did this SDR analysis. CODIS. Look at him being smart. Look at him being smart, judge. Look at this. Because so far, in none of these court filings so far that we covered, did anyone mention the car? I mentioned it. I've said it a million times tonight, right? That the car led them to him. But it's not been in any of these filings, but Judge picked up on it. Meanwhile, law enforcement continued to investigate the homicides. They conducted a video canvass in the area of the King Road residence. Affidavit of probable cause, statement of Brett Payne. Literally, we've read this just tonight. Yep, provided to the FBI examiner. Here is the bit about cars. We read this tonight. Look out for the Elantra. Look out! Located in Washington. Yep. And then the bushy eyebrows. The travel was consistent with the Elantra. They got all this we read in the probable cause affidavit. We read it tonight. Then the trash. So here's again the thing, right? This is in the probable cause, people. Why does the trash matter? Oh, dad DNA, right? Pennsylvania agents recovered the trash from the Kohberger. And remember what I said before I read any further. I'm closing my eyes so I don't cheat. Remember what I said? I said the fact that they included the dad trash in the probable cause affidavit, and it was like literally the next day that they had the arrest warrant and they came to the house. That was like the thing they were waiting for, right? I pointed that out earlier, but I'm just reiterating. I wonder if judge is going to think that's significant as well. Pennsylvania agents recovered the trash from the Kohberger family residence. The evidence was sent off to the lab, blah, 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 dad DNA. On December 30th. Okay, right. So they got the deed. It was on the 27th is when they raided the trash. On 28th, they got the profile on the 30th. So it wasn't the next day. Sorry, it was 2 days later. Okay. On December 30th, 2022, Kohberger was arrested and charged with 4 counts of murder. And then the search warrant for his DNA was issued. Okay, IGG. On June 16th, this is what we read. Well, one of the things was the first thing we read. This is the first thing we read tonight. State filed a motion for protective order. Sorry, it was the second thing we read. The first thing we read was the PCA from Pennsylvania. Yeah. Okay, this was the second thing. On June 16th, state filed a motion for protective order. Brings to light the law enforcement's use of IGG to find a lead. Look at this, though. So remember, guys, how I've been saying we're all confused. Why are we all confused? Look at this. We have every reason. It is unknown to this court exactly when exactly law enforcement employed the use of IGG. Right there. Why have we all been confused? With good reason. Clearly. Judge is like, this really is all vague. I have no idea. We have every right to be confused. Oh, you're talking about the hearing scheduled for Luigi, not Bryan Kohberger. Now that makes sense. Okay. Again, I'm not able to really look at the chat because I'm reading this. And yes, let's look at this. It is unknown to this court when exactly law enforcement employed the use of IGG. Thank you for saying what we're all thinking, though, because this is what I'm saying, right? I'm like, I don't understand it. And when they used it and how all that matters, like so much. And you can only see where this is going to go, right? Because he's like, I need to know what's going on, I would imagine. A brief discussion. Okay, we don't need to go through the background of it. I'm pretty sure we all know. By the way, side note, I submitted my DNA to, what was it called? My Heritage. Is it going to be listed on here? It's one of, there it is. There it is. Here. Here. I submitted my DNA there probably last winter, but the winter before, because my brother did one, and I think he used Ancestry or whatever.com, but he learned that we have Russian heritage, and I thought he was joking because my brother likes to joke, and I was like, what? And so anyway, so I sent it off, not to build a family tree or whatever. I just wanted to see the ethnic buildup or whatever you call, ethnic makeup, because I thought it would be really interesting. And so I actually know what this entire process is like. And I will say that it's on that site anyway, it's an automatic, you're opted out to be on GEDmatch. Like, you're opted out automatically. And if you want to be opted in, you have to sign a bazillion forms. They make it really difficult. And by opting in, what I mean is allowing your law enforcement, Now, again, we learned in that one hearing with the people about the IGG that they have workarounds, unfortunately. But at least I can say this one website right here does their due diligence to protect consumers in what they choose. If there's other fuckery going on, that's, law enforcement doing that or whatever. But yeah, okay. But yes, so based on the identity of the person from whom the crime scene sample is often unknown, they usually use a false name. Again, why does this matter? Because they had the name first. And remember, like I said, is it possible that they submitted the name instead of this, like they backwards it? Like, you know what I mean? They submitted the name to see if they could like double check, yep, looks like a match or whatever. Because again, usually, like I keep saying, you do this when you don't have a name. That's where you get the lead. And that's why it takes time. And again, the timeline itself doesn't make sense, right? Because it wouldn't have been enough time to do any of this. Okay. Then when their John Doe matches someone in the database, they use the genealogical data to determine a common ancestor who might be a great-great-grandfather or grandmother. Look at judges like, here's how all this works. Bicka Barlow, one of the witnesses who testified on behalf of Kohberger, explained the process of IGG. The use of these databases like GEDmatch does not necessarily lead to a single individual as a potential suspect. The determination of who or who is not a relative is subjective and based on the length of the DNA shared between two individuals. The comparisons in such a database do not yield the identification of someone identical to the SNAP data. Rather, it would identify possible relatives who might be in the database. Once a putative relative has been identified, and remember, we even saw this again in, let me pull this back up, guys. Hang on, bear with me. Because look at this. Look at the languaging here. Let me find this part. I think it was in the first document because this matters too. Let me do a control F myself because none of this comports with how this is supposed to work. It was something from the state. Hold on, give me just a second. Was it in? Hold on. Because even this part, they didn't. Why is it not? Okay. Let me just look for it with myself eyeballs. Because I will find, I'm 1 second away from finding this, guys. This is such a mess. There it is. There it is. There it is. Found it. I told you guys. I'm okay. So let me just show you guys what I'm pointing out. So, okay. The determination of who or who's not a relative is subjective and based on the length of DNA. Oh, wait, sorry. No, I meant to go here. Right. It leads to a pool of individuals rather than one, right? A pool of individuals rather than one. Now back here. Here we go again. I got 2 for 2 with my memory tonight because I found this with my eyeballs. Control F did not find this somehow. I typed Bryan, Control F did not find it. I found it with my eyeballs. Look at this. Look at how this is completely not the way this is supposed to work. I think I even said this when I read this. Hundreds of relatives as well as familial connections between each other and the suspect. Bryan C. Kohberger. As if to say this one person was in common with everybody. It led to one name like this, right? This seems like this would only work if you're reversing it, right? Where you're checking the name against the family tree, not the other way. Like, remember, this is not how Bill Thompson is explaining this, how this happened is literally not at all what we're seeing from anybody else. That's not how this process is supposed to work. Look, even just the way you've got colon, Bryan C. Kohberger. I mean, dude, it's not even discreet, is it? Jesus. What is a fig program? Sorry, I have not been looking at the chat, guys. Let me take a look. Congrats, though. Sounds like a good thing. Okay, so Long Crime is, I guess, speculating that Luigi might waive extradition. Okay. Yep. Oh, cool. That's neato. From the other perspective. What's the other perspective? Sorry, I probably missed something. Oh, Franks, you're going to be our local expert then in the Squirrel crew. Yes. Franks, you know what? You are the woman for the job. I can see this. I can see this. I can see this. This makes perfect sense. This makes perfect sense. Franks is a gifted and skilled researcher, people, beyond anything you've ever seen. And this just makes so much freaking sense. Dude, Franks, I'm so happy for you. And I'm so excited. Please, dude, we love it. This is awesome. Are you going to learn more about DNA? I'm so excited for you. That is so great. Congrats. Congrats, Franks. You deserve that. And they're going to be lucky to have you because you're awesome. Awesome. So what's interesting is now Judge is quoting the state's use of the way the state described law enforcement's use. And I wonder if he's going to cite the exact same thing that I just did, where they mentioned the name specifically. Yup. Holy shit, you guys. For anyone who thought, a lot of people have talked shit about Judge. The thing I just read, look at this. Judge caught it also. So 2 things so far that no one in the other filings caught, but I pointed them out, and Judge is pointing them out. First thing was the car. That's how they got the name first. Second thing, that what the state says literally contradicts how it's supposed to work. This thing I just read, remember I went and found that on the document. There it is. Holy shit. Wow. I got goosebumps, you guys. Okay. And now he's also saying, again, this is from the state's motion for protective order. He's quoting the state again, right here, right? Nothing about it was, or a family tree was used by law enforcement obtaining in the arrest warrant or the search warrant or any other search warrant in this case. Now there's a footnote. At oral argument on August 18th. So that is the day where you have the people come at the hearing for IGG. The court asked the state directly if any information obtained from the SNP profile, the use of IGG, or the family tree created was used to obtain any warrant in the case. Okay, so the court asked the state directly. The state represented that it was not. The court has confirmed that nothing about the use of IGG or family tree was used in the affidavit to obtain the arrest warrant. Okay, so again, like I keep saying, right? They don't say the words family tree and they don't say the words IGG, but they say all of the other words. The DNA on the knife sheath, the dad trash DNA, and all of it. again, it's almost a bit weird that they're leaving out the key words, right? And then there's plausible deniability. But what he's saying is technically true, right? But that's part of why it's weird. Okay. While the FBI no longer has access to view much of the information it used to create the family tree, the state acknowledges that the FBI does possess the family tree itself. Notes jotted down by FBI agents as they constructed the family tree, and any records created to document the removal of it pursuant to the DOJ policy. The state has represented that it has already disclosed the suspect snip profile to the defense. Snip, snap. A portion of the motion to compel from the defense asks the state be required to turn over the following. And we already went over this. Declaration of Bicka Barlow. Right. On August 29th, the state filed a notice. Right. So remember that hearing that happened. Right. All right. The hearing on whatever it was. I guess it was the 28th or whatever of August, the one with the people. I keep saying that. Hopefully you know what I'm talking about. That testified. And it got cut short, like, because they didn't get to cross. And then I was actually looking for the rest of it. And I was like, where's the rest of it? Well, now I know. The state decided not to cross-examine them. That's why. So that's why there was no part 2. Which is interesting. That's interesting that they didn't cross-examine them. Huh. You know, the thing is because it didn't happen, I feel like it was easy to miss that. I did, right? I mean, it's like, because it didn't happen, like, we would have been just thinking, oh, I guess it just hasn't happened yet. And then you forget because it didn't happen. But the fact that they decide, like, this is like news to me, because again, I was just looking for this today. And I spent forever looking for it. I'm like, where is it? That is weird. So they waited for the day to finish. And at the end of the day, they were talking about cross-examining, like they were going to do it. And then after the fact, they filed a response, or they filed, where'd it go? They filed a notice of intent not to cross-examine once the court hearing was over, like the next day. That's weird. That's weird. Okay, the case law. Normally I would be reading all this, but I just don't know that that might be pertinent at some point. I don't know that that's what's as pertinent now at this juncture. I don't think we've made it that far yet. I feel like there's the other issues are like prior, before even weighing the case law, if that makes sense. You know, I would assume all of this is with the assumption that the IGG process was done normally and correctly. And anyway, I have questions. You know, so analysis. Supervision of discovery is a discretionary power of the trial court. Trial courts have broad discretion. The state's argument is that the IGG information is not discoverable under Idaho Criminal Rule 16. And if the information is discoverable, good cause exists for the court to issue a protective order. The state's response to the defendant's third motion to compel says if the court finds that the IGG information is relevant to guilt or punishment, still. Oh, I guess they're talking about the phases of the trial. This just seems so, what's the right word? I don't know. I'll think of the word when I'm not, like, biblical? I don't know. The state is simply asking for an opportunity to provide additional information to the court in camera. The defense argues that the IGG information it seeks falls within the ambit of rule, blah, 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 blah. We got all that. And Kohberger has the right to discover and question. Yes, we've read that. Okay, material preparation to the defense. Interested to see what he will say here, because we were just talking about this. In support of its argument that the IGG information is not discoverable, the state argues that it's not material to the preparation of the defense, because defendant is charged with killing 4 people, not being related to a particular person. Wait, did they say that? How did I miss that? You got to be kidding me. Wait. The state argues that, quote, the IGG information is not material to the preparation of the defense because defendant is charged with killing 4 people, not being related to a particular person. What? This is like toddlers. Like, I know you are, what am I? What? The mere fact that uploading the completed SNAP profile into a publicly available genetic genealogy service led law enforcement to allege the defendant does not affect the strength of evidence against him. I feel like every time the state talks about this thing, DNA, IGG, I feel like it's a bit different. What do you guys think? The family tree, here we go again, built by the FBI well, again, this contradicts what Bill Thompson said earlier. Merely pointed law enforcement to the defendant. Law enforcement followed that lead to develop substantive evidence of guilt. Wait, what? Hang on, stop everything, because now they're saying will be used at trial. This is exactly what I'm saying. Literally, there's not been one statement, even just from what we've covered tonight alone, that the state has not contradicted itself directly, like internal contradictions. I can't even believe I'm reading that. That was so far the one thing that seemed like they hadn't contradicted themselves on. What? Hang on. What? I can't even. The law enforcement followed that lead to develop the substantive evidence of guilt. Okay, I guess they're saying the evidence of guilt. I don't know. It just... Maybe if he means the evidence of guilt, not from IGG, he could have said that in a more clear manner, I think. The state contends that the only relevant DNA evidence is the DNA found on the knife sheath and the DNA taken directly from Kohberger. The defense argues that the IGG information sought is material to the preparation of the defense because the defense must have an opportunity to challenge how the IGG profile was created and how many other people FBI chose to ignore during their investigation. The processes used in this method of identification may be extremely important to Mr. Kohberger's defense. The timing and steps utilized are extremely important. Oh, interesting. Okay. As the Idaho Supreme Court recently explained, materiality in this context has not been defined by the Idaho criminal rules nor by Idaho's case law. However, the federal rules of criminal procedure, as I lovingly call FCRIMP, provide a similar right to the defendant for the discovery of documents that are material to preparing the defense. FCRIMP 16A 1E, where a federal rule is identical in material respects to an analogous Idaho rule, this court may look to decisions on the scope of the federal rule for guidance on interpreting or Idaho. Absolutely, they may. Yep. That is a higher authority. Federal court decisions have prescribed materiality as follows. Materiality is a low threshold, satisfied so long. Remember, like what we were just saying, right? Like the way that the state is like, it's not guilt or punishment. They don't need it. It's like, come on now, right? Because they should be able to. So anyway, this is how the federal courts have been describing. So when materiality, right? Is it material to the defense? This is their standard. It's a low threshold, satisfied so long as the information would have helped to prepare a defense. Notice what it's not saying. It's not saying totally points to guilt or punishment, just to quote Bill Thompson. To show materiality under the federal rules, the defendant must demonstrate that the requested evidence bears some abstract logical relationship to the issues in the case. Notice that this is highlighted, emphasis added by judge people. Why won't it let me highlight? It's doing that thing. Look. To show materiality under the federal rules, the defendant must demonstrate that the requested evidence bears some abstract logical relationship to the issues in the case. That pretrial disclosure of the disputed evidence would enable the defendant significantly to alter the quantum of proof in his favor. The evidence is material as long as there is a strong indication it will play an important role, not just guilt or punishment, in uncovering admissible evidence. So it doesn't have to be it's an aid. Yeah, aiding in witness preparation, corroborating testimony, or assisting impeachment or rebuttal. Yes, this makes way more sense. I love that judge added the emphasis here. If I were the state, I would be running away with my tail between my legs, honestly. Hello, Cheryl. How are you? I don't know what's convoluted. I need to go back and I haven't been looking at the chat. Let me go back. Oh, did you mean contradicted? I don't know. I don't know what you, Frank's or Flash. I don't know. You don't need to feel bad. I don't know what you're even referencing here because I've been reading my documents, but you're all good. You're all good. Everyone's all good. No one needs to be sorry for anything. Yeah, everybody's good. Okay, so okay. Okay, so first, okay, now back to Bicka Barlow, who said it was imperative for them to know for the defense. They would like to know whose DNA matched the SNP DNA profile. And who else was I? Yeah. An IGG search can impact the statistical rarity of a profile in a manner similar to a cold hit search, meaning that the statistic is generated by an analysis of an IGG search could yield a relevant admissible statistic. The research is still ongoing. And maybe Franks will be able to talk more about that as she becomes an expert. An absolute expert. Mercer testified that a SNP profile can shed light on the reliability of an SDR profile, but first one needs to know how the SNP profile was obtained, the lab process, the family tree, and 2 on the family tree was not tested for SDR purposes. That's interesting. Additionally, according to Barlow and Mercer, the SNP profile and the information gathered from it can be used to attack the rarity and reliability of the SDR profile, which the state will present at trial. So again, even though they're not going to present the family tree in the IGG, it's related. It could potentially challenge the state statistic. Okay, while such a challenge seems futile since the IGG information was not used to obtain the search warrant, again, for Kohberger's DNA will not be presented at trial by the state, the court cannot say with certainty that the defense team could not make a successful challenge if given the information they seek. So obviously, you know, if you're the state reading this, you can tell he's saying, yep, we're gonna turn things over to people. So at least some of the IGG information the defense requests bears some abstract logical relationship to the issues in the case. Again, he's quoting here from the FCRIMP, as I call it. And based on the defense experts and limited case law on the use of IGG, there is some indication that the pretrial disclosure of the disputed evidence would enable the defendant significantly to alter the quantum of proof in his favor. And again, the low threshold, and now scientific tests or experiments. The fact that just there's a lot. We uncovered a lot tonight, I feel like. It is undisputed that the SNP profile itself is the result of a scientific test done on the evidence in this case. That's the knife sheath, right? The snap on the snap. Hey, heyo. Snap on the snap. Thus, the question becomes, is the family tree and notes related to building the family tree results or reports of scientific tests or experiments made in connection with the case? Arguably, although computer generated, the comparison of the suspect's SNP profile to other SNP profiles uploaded by individuals to genealogy services is a scientific process. SNP data can also reveal whether users share segments of their genome with other users. A bunch of sciencey stuff. Thus, the results from that comparison process, which SNP profiles matched with the suspect's SNP profile, are results of scientific tests made in connection with the case that must be disclosed to the defendant. So again, another one for the defense here. These results would not encompass the whole family tree that was likely built using publicly available sources or notes taken by agents working on the investigation, but these results would include the list of the SNP profiles generated from the genealogy services that connected with the suspect's SNP profile and the percentage. Yeah, so he's being reasonable here, I feel like. Police reports. Okay, the state argues that the records of IGG do not fit into the description of reports or memoranda. The state further argues that even if the records constituted reports or memoranda, this subsection only applies to records in the possession of the prosecuting attorney. And the state does not possess the FBI's records to IGG. But wait, I thought the records disappeared, though, Bill. Spicy Santa. Again, the state acknowledges the FBI has the family tree itself, notes jotted down by the FBI agents as they constructed the family tree, and any records created right, but they don't have the show your work bit. Possession, custody, or control of the prosecuting attorney. As noted above, the state argued in its reply that information in possession of the FBI is not within the possession of the prosecuting attorney. In a footnote in its motion for protective order, the state made the same argument. Even if the notes jotted down by the FBI agents or the FBI, or sorry, if the family tree constituted reports or memoranda, as explained above, those records are not in the possession of the prosecuting attorney. Do you guys see a problem here, though? Oh, my God. Because it's like, well, they're not in your possession because you claim they disappeared. So then you can say you don't have them? Look at this. This is just, this is a bit too convenient, though, I feel like. In interpreting in the possession, custody, or control of the prosecuting attorney, the Idaho Supreme Court recently held that, quote, if a law enforcement agency is involved in the prosecution of a defendant, then the agency's records, which are material to the defendant's guilt or innocence, are effectively within the possession, custody, or control of the prosecutor. Again, Judge is not seeing it in the state's way here. Like, let me read that again. The way that one interprets this, right? In the possession, custody, or control of the prosecuting attorney, the Idaho Supreme Court recently held that, quote, if a law enforcement agency is involved in the prosecution of a defendant, aka in this case, the FBI, then that agency's records, which are material to that defendant's guilt or innocence, are effectively within the possession, control, or custody of the prosecutor. Now, the exception maybe to that would be, oh, they disappeared. While the prosecutor is not required to comb the files of every agency, the prosecutor's possession, custody, or control of the evidence may be presumed if the agency participates in the investigation of the defendant, or the investigating police agency holding relevant and material evidence acts as an arm of the prosecution. Yeah, like the FBI. Here, yeah, keep reading. The FBI was working in conjunction with the Moscow Police Department and the Idaho State Police to investigate the homicides. From the court's understanding, the FBI set up a public tip line, conducted the IGG analysis, identified the suspect car as the Hyundai Elantra, and possibly aided in interviewing witnesses outside of Idaho. Adobe likes to be special sometimes with the highlighting and not. What is it doing? Okay, everything's blue. Now it's not blue. Okay. The FBI was indeed a law enforcement agency acting as an arm of the prosecution to investigate this case. Thus, the FBI's records pertaining to its work on this case are records within the possession. Oh my God. Adobe. Oh my God. Okay. Possession, custody, or control of the prosecutor for purposes of discovery. Again, it's like this all counts as discovery, people. He's just looking at some case law here. Here, the state has made it clear that it does not intend to produce any evidence or witness testimony at trial regarding the IGG information. Thus, unlike in Fuldesi, Kohberger will not have the opportunity to cross-examine anyone involved in the IGG investigation to challenge. Oh, that's a good point. Challenge anything done during or learned from the IGG investigation. For the reasons articulated above in discussing Rule 16 before, Kohberger has established that there is a substantial need for at least some of the IGG information sought so he can potentially challenge various parts of the state's case against him. Although it is feasible that with the SNAP profile, the defense may be able to conduct their own IGG investigation and learn what the state learned, such work would be time-consuming and expensive and could constitute an undue hardship on the defense. Informants. The state argues that the genetic genealogy services and the individuals related to Kohberger whose profiles matched the defendant's SNAP profiles are informants. Okay, that's how they call them, is informants, even though they didn't like inform anybody. It's like that's what they call them, whose identities are protected. Okay, so this makes sense. This makes sense as far as it goes with the IGG and the people in the family tree, and they have their information. The way they're handled, at least at this juncture, you know, as it pertains to the law, they're considered to be informants in this, you know, if they're used with this, right? And therefore, that's how they're able to keep their identity protected. That makes sense because we know the law is very slow to change. And the way that they were able to protect them was to put them under the category of informants, even though they don't even know that they were used, probably. Disclosure must not be required of an informant's identity. Right. So again, this is how they're able to ensure their protection is by calling them an informant, even though it's like not an informant. Right. That's protecting the identity. I mean, then the thing is this, there's a way to do this without, you know, obviously, without breaching that. The The non-disclosure policy exists to preserve anonymity and to encourage citizens to communicate their knowledge of crime to law enforcement officials. However, the extent of informant privilege is not absolute and must give way where the disclosure of an informer's identity or the contents of his communication is relevant and helpful to the defense of the accused, or is essential to a fair determination of the case. Determination of cause. The decision to require disclosure of the confidential informer's identity is left to the discretion of the trial court. Okay, there you go. They must conduct and so this is in the rule. They have to conduct an in-camera examination. Well, there you go. That wasn't just Idaho being funny. That's literally, I mean, this is in the Idaho rule, but I would imagine this is probably similar because, again, it's dealing with informants. That's something I didn't know. And that's interesting to think about, right? When you think about the stuff with the IGG, that the names are protected as like an informant, right? So that makes sense. That makes sense. That makes a lot of sense. I'm glad we learned that. And that's how they deal with it right now. The in-camera hearing provides the trial court with an opportunity to determine the nature and extent of the benefit to the defendant from disclosure of a confidential informer's identity. It is desirable and proper to hold such a hearing before ordering or denying its disclosure. The decision whether to hold an in-camera hearing is discretionary and should not be disturbed on appeal, absent a clear showing of abuse. Subsequent decision whether to require disclosure of the identity of the confidential informer is also left to the discretion of the trial court. I need to drink some water, people. While the this is what I was saying. While the individuals whose DNA matched with the suspect's DNA profile are not informants in the traditional sense, yes, the court understands the state's desire to protect the individuals from unnecessary exposure who likely do not even know their DNA was used in this case. That's also what I just said. That's so funny. I was like, yeah, I bet they don't even know that it was used. Yeah. An in-camera review of the family tree and other information used in the IGG investigation will help the court better determine the benefit to Kohberger's defense in this case from disclosure of the identities of these individuals, which will help the court. The state argues that good cause exists for the issuance of a protective order, barring even the defense from seeing or knowing the information, quote, to protect hundreds of innocent civilians from having their personal information. I mean, again, though, hundreds of people. How the hell did you do that quickly? Never mind. There's no point at this juncture in asking these questions. But, you know, it's hard not to. And Adobe. And all their info. They risk harm. Oh, interesting. Further, the state contends that if the court requires that information, then the services might make their information less available for law enforcement use. It doesn't seem like the services themselves said that, but the state said that. While the court has determined the discovery of at least some of the IGG information in the FBI's position is warranted under Rule 16, the court, as discussed above, will conduct an in-camera review. Conclusion. Yay! For the reasons articulated above, the court finds that Kohberger has made the requisite showing that at least some of the sought-after evidence, 1, is material to the preparation of the defense, 2, encompasses results or reports or of scientific tests or experiments made in connection with the case, 3, may include reports and memoranda that were made by a police officer or investigator in connection with the investigation, 4, may be of substantial need in the preparation of the defendant's case. However, the court understands the state's concerns with the identities of unknown relatives being made public. The state's argument that the IGG investigation is wholly irrelevant since it was not used in obtaining any warrants and will not be used at trial is well supported. Nonetheless, Kohberger is entitled to view at least some of the IGG information in preparing his defense, even if it may ultimately be found to be irrelevant. In balancing these tests, the court will have an in-camera review, all the information in the possession, control, blah, 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 and determine what needs to be disclosed and issue any protective orders necessary. Woo! Okay. That was the most recent of like the substantial documents. Well, I guess I think I haven't gone through the ones this year, but I feel like that was the bulk of like the heart of the issues that we've been talking about, right? And then what we've been dealing with this year is really, I guess it kind of was put on the back burner during the whole change of venue thing. And now we're seeing it again, right? In terms of the motions to suppress, but it's not giving us any information the way that these documents did. As far as what we can learn right now about the DNA and the IGG, I think this batch of documents we covered tonight is where we learn the most. Now, having said that, there's also the hearings. But the hearing with the people, as I keep calling it, is really more about the process of how they do that. Now, it's still informative, but in terms of how it was used in this case, according to law enforcement, according to Bill Thompson and that can vary depending on which document you're reading. But this batch, I think, was the most informative, in my opinion. But I'll do another double check and make sure that, but I think that this is where we get the most, to be honest with you guys. Now, here's what else I have. So this is from Forensic Genetic Genealogy thing. Okay. There are no laws that specifically regulate how these sites collect, handle, and share data. In contrast, DNA entered into CODIS is subject to state and federal statutes. Blah, 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 blah. Where DNA is collected upon arrest, they do all these things. CODIS, yes, we know. Second, genetic genealogy requires significantly more and more revealing genetic data than limited information collected in a CODIS. CODIS profiles typically consist of 1 or 2 alleles. Again, that's all over my head. And there's the STR. In contrast, genetic genealogy profiles are made of more than 500,000 SNPs. Okay, I see what they're saying. So the type of DNA they use reveals things like family members. I see. Okay, right. This means that both CODIS and genetic genealogy databases can identify some biological familial relationships. However, given the extensive genetic information contained in SNP profiles, genetic genealogy sites are able to predict indirect and even very distant familial relationships. Currently, the CODIS loci, when combined with Y chromosome DNA, YSTR, can only identify father-son relationships. Interesting, just thinking about the dad trash. Any attempted identification of more distant relatedness, even among siblings, is unreliable. Wow. A final significant difference between CODIS and genetic genealogy searches is how each is generally intended to be used. CODIS searches are designed to identify the person behind the forensic sample. In contrast, genetic genealogy searches are designed not to identify a single individual, but to find as many of that person's potential biological relatives as possible. And again, this makes perfect sense based on what we were reading, where it's not supposed to give you a name. It's supposed to give you as many names as possible, the opposite of a suspect, right? For this reason, initial search results could include hundreds or even thousands of people. Okay, how it works. Frank's probably already knows all this now that she's becoming an expert. Law enforcement FGG investigations tend to follow a typical pattern. Police investigators contract with an individual, frequently called a genetic genealogist, although there is currently no standardized training for this position, or a private company to conduct an FGG search. This individual or company may be employed by or an independent from the genetic genealogy service hosting the database of the user's DNA data. The investigator provides the genetic genealogist either with a sample of DNA found at the crime scene or with data generated from that sample. Then the genetic genealogist uploads the DNA data either under a pseudonym or via a private law enforcement account to one or more of the genetic genealogy services like GenMatch. The site's algorithm will identify biological relatives and predict how distant or close they are. This will result in a list of names and identifying information. Using this list, the genetic genealogist will conduct traditional genealogical research through public records, social media, and other sources to build a family tree and try to narrow down potential suspects. They look for relatives who are around the same age. You can see, when we hear it explained why it takes time, even just reading this, you can see how it takes time, right? Like they use the social media. It's not a quick process. And yeah, okay. Trying to figure out where are they in the location again, but you're using, again, like it's just investigative stuff. The genetic genealogist will compile a report that includes the names of potential near and distant relatives. If the police have contracted with a company called Parabon Nanolabs for the FGG search, Parabon may also provide a computer-generated image. That is really interesting to know. That's really interesting to know. I mean, all I have to think about is this. Did they do that in Kohberger's case, and did it have bushy eyebrows? Okay. Once officers have narrowed down their potential suspects, then they survey all those suspects until they can obtain a discarded item like a straw or a beer bottle or a dad trash item that may contain the individual's DNA. Officers collect a DNA sample from the item to determine if it matches the DNA found at the crime scene. If it matches, this is interesting, right? Because we know it didn't match. And so they're like, oh, well, then it must be the dad's. Now, what's so interesting is like, they don't know. They didn't test the dad. It's like, oh, it's so close. It must be the dad's, right? what's missing here, well, not that this thing should make every, like, in other words, what it doesn't say is it doesn't say what happens if you get the trash sample and it's not an exact match. That's not here. That's not here. Like, what? Let me read this again. Once they've narrowed down their potential suspects. Now, again, in this case, they had the name from the get-go. But anyway, they surveil them until they obtain a discarded item like a straw or beer bottle that may contain the individual's DNA. Remember, the difference here is like, for example, like Rex Heuermann, right? Lisk. They saw him with the pizza box, carrying the pizza box and putting the pizza box in the trash. So like they had a direct visual of him in the pizza box. What's different here, right, is like they just collected the trash. They didn't like see him. I mean, from what we know, right, is what they saw him discarding was going into the neighbor's trash or whatever, right? But in other words, it wasn't like they saw him with something that would have his DNA and they saw him discard it. They just went through the trash. So that's a bit different, first of all. But yeah, obtain a discarded item like a straw or a beer bottle that may contain the individual's DNA. Officers collect a DNA sample from the item to determine if it matches the DNA found at the crime scene. If it matches, police will then seek a warrant. But it doesn't say what they should do if it doesn't match. I've not heard that been discussed in this case because that's interesting. Wow. Regulation is minimal. Unlike CODIS and established state-run DNA databases, there are still few rules governing how and when FGG may be used. At the federal level, the Department of Justice maintains interim policy guidelines that describe conditions under which federal officers may conduct FGG searches. Unsolved violent crime. It's not to be used for the sole basis for arrest. However, these guidelines have yet to be formalized. Oh, this is interesting. Only 2 states, Maryland and Montana, have explicit statutory limitations on the use of FGG in familial searches. That is interesting. Maryland's law, passed in 2021, is the broader of the two. It requires judicial authorization for FGG and places strict limits on when and under what conditions. For example, it limits the use of FGG to cases of rape, murder, felony sexual offenses, and criminal acts that present a substantial and ongoing threat to public safety. They have to do all this other stuff before they can use it. Maryland's law regulates other aspects of genetic investigations as well. For example, it places strict limits and requires judicial oversight. This is an important protection because, as noted above, officers almost always secretly collect and search DNA from free people after an FGG search. Maryland's law also mandates informed consent in writing before officers can collect DNA samples from third parties. Oh, that's really interesting. Look at this. Non-suspects like family members. Well. That would include dad trash, but also everybody supposedly from the family tree, wouldn't it? And precludes covert collection from a third party who refused to. Wow. Sounds like Maryland's a safe place to live for this type of thing. It requires destruction of DNA samples when an investigation ends. It requires licensing, and it creates criminal penalties for anyone violating all these rules. Wow. Montana has also some protections in place here as well. But is it a match, though? I guess they didn't really specify. Like, the way they use match here, right? I think you're referencing Frank's the dad and BK, right? Because the way they say match here is like the individual, right? Like, check it out, right? Like, the DNA found at the crime scene. If it matches, they seek a warrant to obtain a sample directly from this. So the match has to be to the suspected individual. If that sample confirms the earlier match from the discarded item. I mean, again, they don't specify, but the way I interpret that is it's like like the way that they match the buccal swab to the knife sheath type thing, right? So, like, in other words, the dad trash DNA doesn't match. Like, in the way that this is suggesting, it seems like it's supposed to be the actual suspect and not a family member. But that's just how I interpret that. Again, as it's saying, they don't have much regulation in place apart from these outlier states that are the exceptions to the rule. So Montana does have some protections in place. For defendants and consumers outside Maryland and Montana, there are few, if any, limitations on FGG searching. Wow. GEDmatch states that it only allows law enforcement to access data. Right. In contrast, MyHeritage prohibits the law enforcement use of its DNA services and will not. Yep. Like I said, I've been here, done that, got that t-shirt unless required. Yep. FGG can both misidentify suspects and exonerate wrongfully convicted people. They give the example of the Golden State Killer. FGG has cleared some people who are wrongfully prosecuted and led the exoneration. Discovery and building a record. Ooh. First, defense attorneys need to identify whether FGG has been used in their case. In most cases that have involved FGG, officers have readily disclosed this fact. However, there may be future cases where this is not disclosed. In that case, it is important to question how the police officer found and identified your client. As part of that query, attorneys should also ask whether traditional criminal investigative methods were used. Second, defense attorneys, I wonder if BK's defense team read this website. Defense attorneys should ask for lab records and reports that describe exactly how the company extracted a snap profile from the forensic sample. Low copy number DNA. We heard about that somewhere. Next, defense attorney should ask for specific information on how the FGG search was conducted and the genetic genealogy site or sites that were used. Did officers get a warrant? What was the basis for probable cause? Yeah, this is Parabon. Did you know that, Franks, about this company where they make a picture of the person? That's so crazy. I know, right? Right, I know. And yeah, see, look at Franks is already learning what alleles are. I don't remember what that means. I learned that in whenever middle school. But yes, it doesn't. It is vague. Yes, it is vague. It's definitely vague. It's definitely vague. For sure. For sure vague. Yes. Oh, she already knew. Excellent. Smart. I have no idea. Flash. Franks might know, though. Again, skilled researcher. They should look and see how many people were identified as potential relatives. Interesting. If that number is low, there may be an equal or better chance that the DNA similarities happened by chance rather than heredity. Huh. For example, in one case, Parabon wasn't able to find a close relative, but it did identify two individuals who could have been 6th to 8th degree relations. Based on this result, Parabon stated it thought there was a low probability the case would be solved using FGG, but that it was likely to generate actionable info. I mean, right here. Okay, let me read this paragraph. It is also important to know how many, remember how I kept talking about things going backwards, right? Remember, because they had the name first from the car. That's why that matters. It is also important to know how many site users were identified as related to the forensic sample, how the algorithm determined those matches, how law enforcement narrowed down its search, whether law enforcement followed up on any other potential matches, and if some potential matches were rejected, why. These facts may be useful in determining if confirmation bias was at play. For example, starting with the name and then double checking through IGG. Did law enforcement, after learning of potential matches from different genetic lines or from a car, decide to follow up and build a family tree for only one of those genetic lines because it pointed toward an individual who they already suspected? Right there. That's it. That's literally what I was saying, been saying. I mean, that's what I was thinking, but I didn't know that that was something that like maybe really like inside, like from a scientific perspective, like anyway, I just didn't know exactly how that would work, but like this is saying what I was thinking anyway. But I mean, it was just common sense in my opinion, just because of when you look at the timing of it, right? Again, they had that car first and everything else would have taken so much more time. If they were to actually go through and do this process the way that it is outlined, where you start with the sample, don't start with the name, start with the sample, it would have taken so much longer, you know? It's like, and then they got the dad trash, and then it was like, get them boys, so to speak, as they say in the olden days. I don't know. Obviously, reading all these documents is making me a little bit crazy. Okay. Also, I think my eyeballs hurt. Oh, thanks for that tip. Franks is helping out Flash in the chat. Love it. Love the teamwork. Excellent stuff, guys. Excellent Squirrel teamwork. So I think my brain is thoroughly exhausted from trying to piece all this together. And yeah. But if you guys want to watch the hearings, the hearing, I guess, if I can find that second hearing that was referenced earlier from November, that it would be hearings plural. But if you guys want to watch the hearing where they have the people, as I've been calling it all night, the witnesses, and that was from August of, when was it from? August of 2023, I think. I think that's when it was from. Anyway, let me check. I've got it pulled up. We can totally do that. Let me see here. Yes, August of 2023. We can totally do that on a different live stream. I still need to follow up with all my trash research, but that'll have to be for another day because I have, actually what I could do is, I think tomorrow night I'm going to do the rest of the state's objections, and we could follow up with the trash then. But yeah, I have case law about the trash. Speaking of the trash, I have case law, and I did some more research on that. And then, yes. Oh, that's interesting. So yeah, by the way, I know that both of you guys are in the Discord too. So, you guys can continue the research conversation too. I did say trash. Yes. Because of the dad trash, as I've been calling it, right? They got the dad's DNA from the trash, and there's a lot of crazy circumstances surrounding that trash. So, which is a whole other issue, right? Like, even if you take out all the IGG and whatnot, like the trash, now again, it's like the question would be, did they actually rely on it? I guess that's the same question, right? Because essentially it's like, it seems like they relied on the trash, right? But at the same time, they don't explicitly say it. Like, in other words, the dad trash is in all the documents and it's in all the warrants, but they don't say we relied on it. So it's just like the IGG, where it's clear that it's like a huge thing where it's like, after this, we made the arrest, right? Type of thing. After this, we got the search warrant, but they don't explicitly say that. It's just like, my 4-year-old niece could figure that out using common sense when you just look at it in the order of events. Anyway, but yes, for anyone who's new, please feel free to join the Discord. I'll put another link in the chat. Yeah, so because the trash is where we kind of got going on, and then it's just side questing all over the place because there's a lot to think about, and one thing leads to another. But I do have all the research still saved from the trash research, so we will do that, I think, probably tomorrow on the next BK live stream, and we will finish the state's objections. There's not been anything new on the docket, honestly, thank God, while we get caught up. But yes, there's plenty of other things happening. So Flash fan says, if you join the Discord, you'll get ice cream. Accurate. Nightbot will give you guys ice cream because he has little hands but a big heart. Yeah. I love Nightbot. You guys know I love Nightbot so much. But happy to see some new faces, and of course all the familiar faces. Everybody's welcome. I'm so sorry that it's hard to read the chat while I'm reading the documents because I only have one set of eyeballs. But normally I am very much more able to read the chat, especially like if we're watching something, right? Like a hearing or a trial. So I apologize for missing anybody's comments. Please know that I love all of you guys and I value what everybody says. I value everybody's opinion. I love diversity, and I love people feeling like they can share their opinion and share their knowledge because you guys are great. You're very welcome for going live. But I hope to see you guys all soon, hopefully tomorrow. I think I've got 2 live streams scheduled for tomorrow. But yeah, y'all are the best. Thanks so much for being here and being a squirrel. And congrats again to Franks on joining the Figs. Wait. That's just so funny because Frankiefigs. just is not F-I-G. Interesting. F-I-G-G-S. Wow. Was that on purpose? Anyway, works out perfectly for you, Franks. And love you guys. And I'll see y'all on the next one.